obia ebe obia kwaba e de baba Grace TV so bi se twedi ampo nyanko panto mabusua obia ho ye yasa hia bi mother mama mesre so be kan ho e wo channel yi so a na wa like na wa comment na wa share ama front so enya bi ahwe mi se obaye ntinya mi sure na onye so akoma so ade emfa mabusua ibedi nkomo bebre ni nyina afa court nsensem a sesi a emu asa kanya biem na bia befa bia Ghana for eche wadwen fam etnisre eni abasa ni na ye in line ye maame Akosua Serwaa na appeal ho nsensem a sabre ya me na okase chese emu nsem aye bebre emu nsem aye dija na onim ye be hyase nyame adom about 18-page document. Yes, about 18-page document and as sabre ya me na okase yensa ka bi me kire appeal no mu nsensem nyina so a lawyer ejina so amanti wako file for appeal no kata fa awodo be se du wotwe 18 enti no yebewa ni na mo ho ni ato ye boase ahwede bia eka na ye no nko a ensem wo mo ka bia wo kirem se bia temuafo bu asem no wo high court so temuafo ne ka bibi sei but on to nseni ani a bibia temuafo kan no one na nya adwe enti na mo wo ye appeal enti na onim o se munya mo abotia madaroma kata no appeal no about 18-page document bi ayensa aka na ye be start se be ti ase yeti me pese ye start free high court ruling na nkasa e di asem poti na temuafo de kan na fi ye de ba besim ahwe appeal no lawyer na kotu I mean emra be do bebre nyame adom yensa aka emra no bi lawyer na appeal no akwanyina so ye ogina so bia o asem we kwa temuafo kan no emra no sisi na mehwe mbanu mu a me ne wonya adwen emban sisi mehwe mbanu mu asem a okan yi ebia nke betimi ayi sisi enti ne ye bedi nkomo pa yense mbre no on your screen the ruling from Kumasi High Court ebra on the 28th of November 2025 the by my meeting for leadership justice during that seminar na odi atemu eba no asem a ugina asodi bua yedi kan hyase fro ansana area ya ba the 18-page document ya ni na atemu no ehon sensem ne appeal a sesi a where for gina the by maame Akosua Serwaa ekwakoye interesting times ahead pa na onim yen hyase ebusu de da so yi yen to your from top to down na yen tin sem wasi madaro na bibi anye boko enti celebrity aka this is the ruling almost a plaintiff honum and aside plaintiff no so your defendant ya almost so ewase honum na won say no American say plaintiff yen nim say maame Akosua Serwaa defendant na wo ye miensa say the yen na ye kaya madaro ma and that's no a defendant na ye miensa first defendant na ye na confuse yes and a second defendant here sister Priscilla Ofoy third defendant no transition funeral homes emmanuel kwani edin ko ni busa say transition funeral homes kwani bi busa say e ba na say na omo ka ho bi let's not forget atemo na atemo ametimu for the buy na o kan say enam say ye maame Akosua Serwaa yere yes sister Odobroni yere eno na fe ya mamre mu nso abusua pani confuse na wotumi say otu anamon bi e fa na de hye ni sie na yie ho ntino onko no nkoye na yie but let's not forget maame Akosua Serwaa de chim koda and court say anka court emfa o hye ento transition funeral homes eso say ko ba say na confuse kura court so ko yi that Lumba mu no a ema ye ma ne kwan bo nko yi Lumba mu no mo nko ye yi na na temuafo ni bu ase no ka say efa transition funeral homes so de oni asotwe bi anase oni be ka say impediment on si o mo kwan say na confuse ba say obeyi that Lumba mu na mo mfama no etu de maame come straight away brony afa madaroma yes so on your screen bra and some doors but temuafo ni bu asem no and some be boss no ye hwe also in the high court held after so church in Singapore but the brinting na yefa na temu no sem kind no also in the high court held in Kumasi in the Ashanti region before her ladyship Justice Dr. Dorinda Smith Alpha High Court Judge on Friday 28th of November 2025 suit number GJ12/20/2026 and your suit number no plaintiff and that's no Akosua Serwaa for suit Schwester Emelindes Work 9 Bonham Shelton 5 3-3-3-2 Germany versus that is defendant. The first defendant abusuapani confused when no. Second defendant Preslaw for yes sister Odobroni. And a third defendant Transition Funeral Home aka Enterprise Funeral Services Hachu Astori Junction Atomic Road Accra. Now judgment in the one but all be judgment no yeah person e kan bibia na yeti ase enti o kan nyame asem bi ho o kan korontofo o ma Paul o ma ohwe koma abusia Paul o ma ohwe koma korontofo Paul ma toso mienu men kan sa Paul ma toso mienu ohwe koma korontofo etire dumiensa eye chichemu enwotwe na we no kan di free New King James Version NKJV na yentie Awurade asem abusia edi wafa Bible abetimi abiem ene yeto ebo ase ya go to bibia once and for one ate ase yi enti temwafo ne chemu ye obebu asem ana o say o ka bibia firi Awurade asem ya Awurade asem o ka bibia firi mu efiri Paul osomafo Paul so a che oboda ne Paul na wo ma otwe koma akorontofo tremienu chichemu dumiensa okay yes Paul osomafo Paul mo otwe koma akoronto asafo no etremienu anase da bi bayi mayefo so won fa nche me Christ ntie ade hye osomafo Paul na woma ye tosumienu otwe koma akorontofo that's the 2 Corinthians etie dumiensa chichemu enwotwe yes so 2 Corinthians chapter 13 verse 8 Mr. What for Bible what be we men twaso menim say be for Bible say be ya ye beti ase we ndi embe kan ye New King James Version also for Bible minti me kan madawma enti ye kan o say Awurade asem ni obusu minti Awurade so we can do nothing against the truth but for the truth na say we can do nothing against the truth but for the truth na say yentimi nya bibia emfa ntia nokre na mom de ebe bia na wo se ye e de ma nokre eno ye Awurade asem a timofo kan ya ansa na odi atemu beba now enti yenwura mu e na fe yenhwe atemu no akasa o kan no this is the first slide of judgment no the next slide no hinfa the next slide ni okay abuzia me ba cho ma fa Bible na marking kind ye to as well no okay I think that this is the continuation okay it's not yet to as well after so go to Awurade asem wie no and what chim no say I want fan plaintiff ni ya wan ye ma me Akosua Serwaa ona dey asem no ko dan court enti on the plaintiff no and what can be on no say plaintiff it is not in dispute that the disease relocated to Ghana and he has been in Ghana for almost 2 decades let's say o chim say and o kwachinye bia ni mu say that Lumba wa betina Ghana be say decade back be 10 years na say finshi abe say diunu ni wa betina Ghana eno ye baako and afei or to also be no say he was born in Ghana asana oba ma tembu no he was born in Ghana hailed from Ashanti and had his lineage as an Ashanti royal into that Lumba ye won Ghana ye won no first of origin into what you say no correct adanse yi na chese Lumba okoye German this year obeye German is answer no by some time back my di na onkomo that Lumba be German this year na so obeye German ni no 1 pound na chi se wo ye Ghana ni 1 pound na chi so free Ghana my mu yeah I mean holding on to the Ghana and I say the Ghanaian origin and I say the Ghanaian heritage said yeah ECTN fata nti okan na won and after what was no say. And even if his domicile of origin was deemed to have been held in abeyance when he moved to Germany, worked and lived there, he revived his domicile of origin when he relocated to Ghana. He revived his domicile of origin when he relocated to Ghana, got married, had 6 children, worked and died in Ghana. And Timothy Chim says, "Simple, you find that Lumba." On say obey German citizen or renounce a Ghanaian identity. And that one for children say obey a German citizen now or renounce a Ghanaian identity. The attorney say embo okoye sali na wi no sa ba Ghana e ba Ghana no according to Timothy for some kind obe ware wo Ghana ha e ma wade no ko obe wo e ma awudo nsia what you say ndi o ware yo ba Ghana oba Ghana ha no obewo ma hudu nsia enti no kwa no ema ɛsan revive ne Ghanaian identity ɛsan revive ne Ghana ni awɔyɛ sɛ ɔpo ne Ghana ni awɔyɛ ebe onya German krata no be German ni no a ebe osan san nchi ba Ghana ha no obe ware wo Ghana ha na obe wo mamunsia no ɛsan ma ne be ye Ghana ni bi enti ɛno ɛho sem kakra ɛno no said yetitie now for what was no say thus the court finds as a fact that the deceased was a Ghanaian domiciliary prior to his death and as such in his habitual residence was guaranteed court who say enam saadie no nti omdom se that Lumba oye Ghana ni anase obetena Ghana ya owuye e wo Ghana memu na nti ye fa ne se ye de Ghana free ni mu a enye yi oye Ghana ni prekope ana no nti sabi na baabi a otena ye ebra we nyame dia no e Ghana nti omamu nchemu no koti some of the evidence ya o che se amponsa versus amponsa no 1997 1998 amokoti hono ma obetimi a reference na wate ase na afi owi na oba atemu na ye buam no ye du hwabi owi na oba disposition bi go ye behwe appeal ne nkrata no doso ti pese edi kan sha se free atemu na ban no ha enti afi owi na oba disposition and as a holding ho and what say I have considered the entire evidence adduced by the plaintiff and the defendant, the exhibits, and the written address filed by learned counsel for the plaintiff and the defendant. What on was and wash and crata in them and crata ben washing or hen crata plaintiff, Akosua Serwaa, lawyer for the Badan court. After what on was it? Ash and crata a year defendant, and why defendants on me and son, yeah, confused first defendant. Yes, the Odobroni second defendant, and after and transition funeral still defendant. Over dancing on the Badan court now. Another than Chenya, afei same for you know, send crater be a bill bit make them mama dancing a cock of you. You know, the Abadan court, or shooting them, and afei Sembia, what at the Abadan court, you know, what Tony Boissy, and I was shading them. Now, shading them, we know, young shay. And I watch say, and in the premises, I refuse the plaintiff's reliefs A, B, C, and D. Afei, I also refuse the relief I of the second defendant and rather grant relief I and II of the second defendant or Bob on same. So in this answer, Bob was with any extra say the chain and say in the result, I hold that the kind Jaffe or what as a nom to shading them on one watch say what you say the kind the plaintiff your mom Akosua Serwaa. The plaintiff was customarily married to the deceased Charles Fosu, aka that Lumba in 1991 in Ghana. And he became boss that Lumba. Whatever me Akosua Serwaa, fear what the fear Pimahan could you 1991. Ghana, a bomb sukumasi. Yes. Afei, or to also be more. The second defendant, why the second defendant? Odobroni 7 years, yes, sister, please love for it. The second defendant was customarily married to the deceased Charles Fosu, aka that Lumba in 2010 in Ghana. But he came boss. Mami Akosua Serwaa ware no fia ware 1991 after what was be more say Odobroni say ware no fia ware 2010 e wo Ghana ni na Ghana and I will say I declare that the plaintiff and the second defendant are the surviving spouses of the deceased Charles Fosu, aka that Lumba until after we say as an tie dia Mami Akosua Serwaa your plaintiff and after a sister Odobroni or second defendant Omo na ya yire no mo a that Lumba eja on omo ewetri enti afi consequential orders say afi ni say wa one say we are dey me to aso the to aso say sa dia the corner royal family of Pakoso and Isuta Ashanti represented by the head of family Ebusuapeni Kofi Usu. The first defendant is hereby ordered to recognize the plaintiff Mami Akosua Serwaa and the second defendant, Priscilla Ofori, to perform the widowhood rite during the burial and funeral of the late Charles Fosu, aka that Lumba. To boy and say, and I'm saying, yeah, my main sister, we na hearing no. Or can your children Kofi Usu say, who yeah, my Akosua Serwaa sister, Odobroni na say, one I hear no more that Lumba jam wechi, enti between I kuna sans na ye ne ba baso, ya na yedi mu ko, between I kuna said the amamre ni amani na say. Na efata. Now, if you also be more say, how that transition funeral homes be no say There is no impediment in the way of the third defendant in allowing the Ekwana royal family of Akosua Serwaa, represented by the head of family, Abusuapani Kofi, access to the body of the late Charles Kojo Fosu, aka that Lumba, to perform his burial and funeral rites. Enti, afi omu chire mu se, esi akwan bia ensi na Kofi Fosu kwan mu, anase, esi akwan bia ensi transition funeral homes kwan mu se, omu beka se, anase, yebe show omu se, mu makwan, ema na Kofi Fosu, emehu ne de share that Lumba. Enti na se kwan mu da o sa abre no, ekobasa na Kofi Fosu koso opeso hu ne de share that Lumba. God to see when see obia kwan. On see transition funeral homes kwan say mo kwan. Emma or mu hu this year. We na say I make no orders as to cost. Now, there's a ruling ti atia say we afi. Yankwai, ni yanko share appeal no. Yeah, lawyer for file about 18 pages. Na yanto ye boase. Entin sem no wase ye na bibia anya bokwa abusua ti yenrem with the appeal no akasa. Na yenti de no so and some more efri mu eba say the city live on YouTube by Grace TV. So obviously about no like it, no commenting, na wa share at the amame said ya say na efata. Okay, so okay. Now you starting free. And to your character here that's ya. Appeal na hons and some no. I mean the Superior Court of Judicature and the High Court of Justice. Kumasi that's court hons and some. Mame Akosua Serwaa was a plaintiff. Afei first defendant the Abusuapani Kofi. Second defendant Sister Priscilla Ofori. Third defendant the transition funeral homes. Now, if you are say the entire transition funeral homes, can be as a defendant because now Mame Akosua Serwaa as a court and show almost a more any that number moon and ma and Akofu se kobase and Akofu eko e was okay that number moon akosi no a esias Mame Akosua Serwaa say oko jama imremu a on the year next of kin since ni kuni that number ma ware court wa wade na court boy o cast there be omo see transition funeral homes kwan say emo omo fa that number mu e man na confuse enti on the entia omo kan be as a defendant e wo appeal no no yes na it also be mu a o say notice of motion application for I mean you're showing them appeal no one sense na enti e fa we do so say application for leave to amend notice of appeal enti na o track at Abadan court as court say court ma kwan no on sakra appeal no sense no mu kakra na I mean this is court and some in course. So after you be rather substantive issue, said the city here. I'm on the way a lawyer still see how poking a trade court and court this part now. A trade court and court say court to man quine. Nanka on sacra appeal in some and they ever be shame near kotu man be one kotu hana. Now say. Now so let's move on to the next page. Okay. So on the next page, when that's not say and for service on and the way say ebra lawyer actually court and court to say or person court man kwan now sacra appeal no sense no e dey ya I was say all the parties no be anya bi and in this case parties be na come one say parties say plaintiff and defendant and the plaintiff as we all know Mame Akosua Serwaa and na lawyer na serve and it was your seven defendants be defendants na one first defendant Nana Kofi's lawyers, your best server will be an actual one. Second defendant, Mr. Odobroni lawyers, your best server will be third defendant, transition funeral homes, also your best server will be said they are ACTNT, and also what they can you're born to tell Tony at say about 18 pages into the OCT say, your becking can have some error. Dear Twaswa, I mean, be me to share baby, I will do ya. Ni na ye court on someone cat and anti afei na lawyer for the change them with the entia wo mutu sa na mo yi e change them kakra say this here na e no na affidavit in support no o say I ama ampon ajiman prempe of 10A Bote Avenue Airport Residential Area near Nyako Clinic Accra in the Greater Accra region of the Republic of Ghana make oath and say as follows in the entia someone ye Mame amanya kon agiman prempe ya okamanu fu gina mo de ma panyufo e kan ho na yenti de omo eka okay and to say that's commission of oath no yenti to say that I am a lawyer in the law firm of Messrs. Kolendi Law, solicitors for the plaintiff applicant herein after court the applicant intino omo say omo de yembranu fo mu gina mu edema applicant ye Mame Akosua Serwaa. Now say that I have the authority and consent of the applicant to depose to this affidavit for and on her behalf nti wanya saa tumi no ya maame Akosua Serwaa ma ne kwan se onfa saa nsem we emedan court asem bi a waka won krata yin bia court oka ma court ati se tumi no maame Akosua Serwaa na de amana se omechirem yi emfa enchire court in the end of what you can say that I have the authority and consent of the applicant to dispose to this affidavit for and on her behalf. Affidavit also say that the content of this affidavit, unless otherwise stated, are matters which are within my personal knowledge, information, and belief by reason of instruction and document received by our law firm in the course of conducting this suit. So say, assembly of boss will be and assembly of church will be and someone. Onu a wonim eye nsem a ya chie mu akire no na wate ase se dia emra Ghana mra ese na fata ebra odi nsem we achi afi wo say that at the hearing of this application counsel for the applicant shall seek leave of the honorable court to rely on all processes filed in this suit as if same have been produced in this affidavit in extenso and sworn to an oath. Let's say a court reference, seven friends, but to the boss, and some more the better court. Is prepare and a chance na their career to us. And after us now said that the applicant commenced the instant action in the High Court, Kumasi, on the 2nd day of October 2025 against the respondent seeking the release endorsed on the writ of summon and the accompanying statement of claim to achieve the what James are saying with Maame Akosua Serwaa the court. That was 2nd of October. And then same way na koda court to chim or my background am ya tin seven was he said this here. And I thought was not say that the applicant commenced the instant action in the High Court Kumasi on the 2nd day of October 2025 against the respondent seeking the release and Medicare Kamwasem. I thought say that after trial, the trial court delivered its judgment on the 28th day of November 2025. Whereafter the applicant, dissatisfied with the said judgment, caused her lawyers to file a notice of appeal on 1st day of December 2025. Attached here to and marked as Exhibit A is a copy of the notice of appeal. And the court to Boasem. Na ye Maame Akosua Serwaa. Na ne bo enyo asemu court to boa this no. Ena bronya bosumi na mu. Okache na lawyer for ye bronya bosumi dey di kan 1st December. Okache na lawyer for essence file appeal at the Bedan court said there is etie. After it was say that the applicant further caused her lawyer to file additional grounds of appeal on the 3rd February 2026 in Tibra. Ye Maame Akosua Serwaa file appeal ni 1st December. 3rd February 2026 afu ye mu. Osanse mo file bi e de nsem bi adanse ne nsem bi kan at the Bedan court. There's additional grounds of appeal. And after chim dia chair aye court say and some of their can will be exhibit on so their some Kodan court one adanse ne nsem a who's a court betimi ahwa no abo ama osem ya koye di ama no and your friend exhibit nto chim dia chair court say exhibit ni bi na e won krata mu ana say what their can with their Bedan court no say the city to a mark exhibit A afi ba kon so exhibit B say the city afi yet was wa say that the applicant subsequently engaged our Stephen Opoku to prosecute the appeal on her behalf, following which a notice of change of solicitor was filed on 22nd April 2026. Also, a camp will be at it. Say, and what she a year, Maame Akosua Serwaa, Kulendi at law, Emma Okofa, lawyer Stephen Opoku say, Omram ne kawan, so Mama Boamu. Na obedi asem no echi emo no me yemra nim ni a obedi asem echi se be ye bibia be ye bokọ se city enti no so om de one dance here but dom court because bibia because we also ma court oh e bia court bibi nti sisa yemra nim ni court bibi nti ye de nsem ni bi be ka ho enti no so om chese om de kodan court ya ho evidence ene ade nyina enso honom se city afei to so say that following a review of the grounds of appeal canvassed in the notice of appeal and the notice of additional grounds, it has become necessary to seek leave to amend the said grounds in order to ensure that same conforms to the rules of court and to ensure an effective and complete adjudication of all issues arising from the judgment enti won say o ma kyerem say aside bibia no omo assign their bar bedan court because ye no and court lawyer say omo the bedan court say still na omo hwe nsem no one temoni bi ho a omo pese court ho omo kwan na nka omo timi enya nsakra ana say court ho omo kwan na omo di nsem no bi be kan nsem no be ho a ye ma meti mo afu bo ya omo na nya adwen na court mo omo kwan na omo fa eno so ma bedan court ena na o kyerem de chair court wa say na mo ntu omo tu no ebi no sa na ma no afa ye to so bi mo say yet also say that following a review of grounds of appeal, that in particular some of the grounds of appeal alleging errors of law were not particularized as required under Rule 8(4) of the Court of Appeal Rules 1997. To say, and some of the court is now to the board. Some yeah, okay, say, and some of the court be and random and name random hard drain and I say, ebia etiamra and running for and to sound among said the Senate Fatana. Almost said there be. Na no mo ho nsem ka said the appeals court of appeals o mo emirate tie no to mo twa da bedan court ye be running name ye nya adanse ni bi wa say afi o say that in particular some of the grounds of appeal alleging errors of law were not particularized as required under Rule 8 Clause 4 of the Court of Appeal Rules 1997. Afi o to also be more say that there are also new grounds of appeal that the applicant wishes to canvass before the Court of Appeal for adjudication. Therefore, applicant ma me Akosua Serwaa. O ma to mbo ase. E de nsem bia to nsem ne ahwe nsem wa se da bi. O ba se woni obebre o ho a. O mo be yi court of stay. Na o ma kyerem le check court da bi. Nyina ye nsem a o mo se court tie na nka otu wa na mo abeboa ma bibia ye boko. Beboa na ma nkunimdie aba o mo afam ti grounds of appeal. Nyina so nti a o mo gina so nti o mo be ya appeal no. Ebi atemwafo ka say na temwafo kan ya mo na nya adwenti na mo gina so ba ya appeal no say temwafo kan na so mo hwe mra no mu a o mo ze mra no so ka say ene ade ye behwe ni nyina wa say na yeti ase na ma bibia enso ayeboko enti no so ye nsem bi abusua obo so na o kan e de etwe court say sitie after what also be no say that the applicant therefore seeks leave to amend the notice of appeal and to file an amended notice of appeal that embodies all grounds that the applicant proposes for adjudication before the Court of Appeal. In the enra, the only and Yamiam court what he has above no. Now, lawyer said there be court. Yes, and some one. Yes, sir, say. And some will be a while. Every and some of the be brave to me, I can be after home. Lawyer and court and some will be a while. Yes, sir, passer, you 2 was a share. A timwa, you might meet him more for the buying. You will say, be and some cry, waiting, why, but me the back. Ya dance ya de bedan court no yes court my kwan yentimi sakra ya appeal ni mu enenra court amakwan say ometimi akosakra mu na omo edi aba after to also say that the applicant therefore seeks leave to amend the anamakan and after say that I have attached to this application a copy of the proposed amended notice of appeal marked as Exhibit D, which in the opinion of counsel for the applicant adequately complies with the rules of court and sufficiently encapsulates the issues applicant would want the appellate court to resolve. You know, or you be running them yes, na be I can. And I want to come need deal water. And yes, I'm kutwa. Na mabobi ogumi mo bon super bi ogumi mo. Na ma yes, I'm kutwa. After to also say that the leave is sought in good faith and in the interest of justice to permit the applicant to present her entire case before the Court of Appeal for determination. And omo kada check court say court we madaroma. And some way the other time say person ka mama kwan na yesakra and some way the other time court no. Also mo di kan appeal no 1st December after February omo say edin some be called in court additional grounds of appeal omo be called in court. And I say omo say court mo kwan. And a court wa dia tuma no omo kwan say omo fam na omo chim say enye say bia sa amendment and we grounds of appeal on the court to amend the mom. Yes, be an a bonus so baby. And yes, be no person on we court one quite no ye Eddie go be any was there be. They move any yemu. I was more like him, saying I'm on my camera, madam. Any yemu said the bear in the interest of fairness, the bear my justice Asantehene ever conso your mind gun never boa now ma ye be kuram madam yentina one more at the better court, sir. Said the ICT. So that this leave is sought in good faith and in the interest of justice to permit the applicant to present her entire case before the Court of Appeal for determination enti ɛyɛ good faith nyɛ sɛ bia ne bonus da bi ne mom emmerɛ mu ɛde die mu sɛ bia pɛpɛpɛ yɛ bɛba na bɛboa ama applicant yɛ ma me Akosua Serwaa ebetumi ne nsɛm nyinaa bɛdan court of appeal na boa ma temu akɔso asodie kwan so afei ɛto aso bi mu a or say that the respondent will not be prejudiced in any way as civil form 6 has not been issued and the record of appeal is yet to be fully compiled and transmitted to the court of appeal. To watch him say, oh, and I'm say, Jacoban is saying, what can you say? No, almost him. Okay, now, where ye full of our and run a bar mountain, yes, main can and run a bar mountain, which is appeal, no, and one sense, the totality and the entirety of it. When run a bar mountain after say court to ma, or quite a bar mountain, in a sakabia, a ja, ye demon come water on my city. And see, me kind to find for. Or say that the respondent will not be prejudiced in any way as civil form 6 has not been issued and the record of appeal is yet to be fully compiled and transmitted to the court of appeal. To what you say, respondent, omo asem no say si said, Mama Akosua Serwaa and plaintiff respondent not confused is sister Odobroni and afei transition funeral homes. Omo emre anim for enko ha dwen obabi asan say wa court bi bi say civil form 6 no omunya issue here and afei record of appeal no so kra no omunya compile with it fully internet kwan so am ya ensehwe and of course court tie ma omokwan and after what that also be no say that in the circumstances I respectfully pray that this honorable court exercises its discretion in favor of the applicant and grants her leave to file the amended notice of appeal. Owie na lawyer nsi opoku ene amanufo omunya say almost say court pass na omade se din as court nyintum na omo kwan na omo ntimi ensakra womo a notice omo de bedan court na so omo appeal notice of appeal no court mo kwan na omo nsakra mo amend mu kakra and na court tie no oje to say ampa mo kwan obetimi asakra na mo de apa enti let's not forget secretary was on the 4th of June and our lawyer for answer shase but omo de bedan court and run a Bible thing in say Kevin paying for the Roma. Yes, Kevin, this man sign said, yeah, it's yet here. Now, if you want to say about 18 pages. Now, the interesting part here about lawyer for the church and say, it be at 1 it's a shall say with making kind to 1 for some kind, so be able to see. A lawyer for the chim, it be at 1 for the cast, and go to and Rabbi in a Yamadu and Saka, money be an hey, and then I call law school about everything. See me, I said, we baby. Now, near my young friend one, but anyway, why am I yes, Yandy? Yes, you might be prepared. And yet was what? But on the bottom, Madame. Was the other slide? Yet was what was young for Madame. Was the other slide? Was the other slide? Yeah, was so. Yet was what? This is it. Yet was okay. And yet was what? After you run 7-1 Casemo. After judgment, no. Judgment no the na Mama Akosua Serwaa lawyers omontiase de bia obi kan de obi che na dwen founding na e be tati as usual ohwe story ahun say Akosua Serwaa fosu Schwester Emirates Bohem Shetem Germany for manyam kasa ya na de cheme versus anakofiusu anyone aka na ho kama pa notice of appeal and so chechem come please take notice that the plaintiff or applicant herein being aggrieved and dissatisfied with the judgment of the High Court, Kumasi, more particularly, stated herein and contained in the judgment of His Ladyship Justice Dorinda Smith Arthur, sitting at the High Court, Kumasi, and dated on the 28th day of November 2025, do hereby appeal to the Court of Appeal against the decision upon the grounds set out in paragraph 3, and will at the hearing of the appeal seek the relief set out in paragraph 4. Enti, na wo chim e da check what say. O check what say. And now, Mama Akosua Serwaa. I think we're by 28th November. I think we'll be the King. I think we'll Kumasi High Court by. That's what Atamami or you would not cancel Madaroma. On okay, no, I aggrieved with it, no, or file appeal. Second to the worst one, him. Na only na semana. Yeah, appeal or file and the already free court on what kind of see Babe can so. And therefore, what also be on say the plaintiff or appellant further states that the name and address for the service with the jurisdiction of the persons directly affected by the appeal are those set out in paragraph 5. Therefore, what I say one more. appeal ya wakwa e be form ho anase benya nsunsuan so wo mo eso no and so achiri na mu wo honom after about part 2 no paragraph 2 now say part of the judgment of trial court complained of intino then atemu ya Kumasi High Court by ambo boss no emu dia wa hin na ya maame Akosua Serwaa ya oye applicant oye the plaintiff in this matter onyintum na ontiase onyintum na ontiase na enunti amana kwa akoba ni sei na tie o say ehemfa o say ruling bit me free court ba na bia ruling na buy no obi timi ka say okay this part of the ruling there I agree perfectly with the court, however this part I don't agree but mama Akosua Serwaa say ruling the free Kumasi High Court by madiki akinka ni na onye nyina ntum ruling na bi ni say court say mama Akosua Serwaa yere e wo fie awade and onye ntum afa ruling ni bi ni say mama Akosua mama hwese me hu sa no na anyway say me atoso sisi anti obi hu afa ruling ni bi ni say yes Odobroni so yere tu afia aware no so onye ntum afa ruling ni bi ni say on transition court so on transition funeral homes kwan sa do that Lumba e body ni share ti ruling bi ni say court can say on transition funeral homes kwan say e bia na kofu so koso okwe that Lumba mu na on si omo kwan omo otumi say omo enyi emu no ma obi ara na kofu so obi on person obi ba ni bi omo nyima na mama Akosua Serwaa say sa clause ni na no anase sa temu na ba ina no only court nya adwen and we hear part of the judgment or complaint or say the whole of the judgment of the High Court Kumasi dated the 28th day of November 2025 ni na only court nya adwen e wo hono afei sa dia grounds of appeal ni say in that one ni say and what chem say and in that one mama Akosua Serwaa say only court nya Kumasi High Court nya adwen bi say the High Court erred when it held that the marriage certificate exhibit B1 and B2 was not admissible per se. No, mama Akosua Serwaa lawyer for say now what the encounter marriage certificate ya or they bar court court here say one into exhibit no a marriage certificate was exhibit be a extract from the family book from Germany extract maybe a tune didn't say B1 and B2 court anyanto no it wasn't admissible no there be on a court nyadwen and a barco after to as well or say the court erred when it held that section 161 of the Evidence Act is a condition precedent for putting weight on an admitted document. Can close now. Or say the court erred when it held that section 161 of the Evidence Act is a condition precedent for putting weight on an admitted document. And there some and section 161 of the Evidence Act na eka. Let's go. Evidence Act no yame adom yensaka Evidence Act ni bi e wo hen fampo ni asem wabusua and then makolo school aba asem ni Evidence Act no wo hen am say mediato baby abusua mama me hwehwe mra wate Evidence Act section 161 where is it where is section 161 of the Evidence Act okay ni na or say okay in Evidence Act section 161 now say a signature in you. A signature is presumed to be genuine and authorized if it is purported to be the signature affixed in his official capacity of an official of an international public entity or a state or a public entity in a state recognized by Ghana, and the writing to which the signature is affixed is accompanied by a certification of the genuineness of the signature and official position of the person who executed the writing. Obeka ya nzane ba we to just say lawyer for lawyer kusino mu ne aka twere koto e de ko Ghana ba na musini or Germany ma mu say omo pese omo authenticate character no man because a man say character be free a man who do be so ba Ghana ha say ya e was a Ghana ba na musini o man mu no e was what in sa chance no tintim however and then you go to the Evidence Act no be able say okay even though man can say but that is not the only way. There's an argument on making said, though rather can say, I was a character free, and here I was Germany now at the end of course. I was a character free Germany member, but then free Germany member be I say, Ghana buy your Germany, and then we see one was a character free na so ye ba. Now authenticating mobile say no kwe. But you can kind the Evidence Act no ejo baby or church and say kakra am say even though this is the rule, however, it is not limited to that. There could be Other means you bet me afa so na ye de agye atum se krataa bi genuine if so authentication here be one thing this be more say that's the evidence act now quote one a signature is presumed to be genuine and authorized if it purports to be the signature affixed in his official capacity of an official of an international public entity or a state or a public entity in a state recognized by Ghana, and the writing to which the signature is affixed is accompanied by a certification of genuineness of the signature and official position of the person who executed the writing. And you know, clause 1 no. After what was clause 2 no. Or say such certification must be signed and sealed. Okay, such certification must be signed and sealed by a diplomatic agent of Ghana or of a Commonwealth country who is assigned or accredited to that country. You know, the country be self-free. In this case, Germany. And what's signed by diplomatic agent of Ghana. And you go Germany. Why the diplomatic agent of Ghana? The diplomatic agent of Ghana or Germany. The Ghana ambassador or Germany. Ain't now back here. Kusinum HM say, "Omo try the corp." Ghana. Abana musini aswe Ghana embassy or Germany. So, omo authenticate criteria mo. But now, omo try the akwa. Omo ntehwe. Na we ka we na sakwa bibi okaka. So this is what the Evidence Act is saying. After say. Enye no kwa se ko boss e bia kro no se nya ba bia na Ghana ba na musini wo because to the best of my knowledge when say okwa aman bi so a e bia aman be se me se na Ghana ba na musini no o hwe wo mo so e bia o man ba ko mo enti ko boss e bia o man no a krata na free wo ba no Ghana ba na musini ni wa on say Ghana ye ka Commonwealth nations so aman ya English aban e na odi yen so enti ko boss Ghana ba na musini bi ni wa ye Commonwealth man say England o say nkrawdo aka English abrofo na di yen so no Omo aban no bia wo ho omo aban na musini bia wo ho so betimi the sasha ase de aba ye betimi abedi dance abe justify e court. There is the Evidence Act then ya no nko Evidence Act na ye kan clause 3 no say tell you if reasonable because away for na ye appeal dia ma Akosua Serwaa say omo e say court no e form ye na court no form free na say omo che say Evidence Act omo quote ye e wo ma Akosua Serwaa temu no mu e section Evidence Act section 161 omo say timwafo no from kakra sana lawyer eka I mean respectfully emremu nyam na meka me minimra men call law school and the clause 3 of the Evidence Act section 161 will say if reasonable opportunity has been given to all parties to investigate the authenticity of a foreign official signature the court may for good cause order that it may be treated as presumptively authentic without certification. Enti ekoba se bia ensem no aba do court no na krata no wasi team so ne ahwe ne agituma bibia eboko no ekoba se o ebia court ama akwanya ama the various factions the various parties obia ahwehwe mo hwe krata no say no kwa krata dem say e court krata de em say ne kwanso ano krata de Ushemwa and the question it is authentic from the foreign official signature near there. And your court no ni ye munti obetimi ahwe na waje to say the Korean krata no authentic. E wa be certification bi akwa e ma ho. Ba lawyer for the say court no mfum so the MT the lawyer for the kan. Okay, him for call am juye. Okay, yenti the lawyer for the kan. Lawyer for the say court no mfum so. Na the yenti omo ka say court mfum so nyina ne say omo say section 161 of the Evidence Act a court no quote you know and from so kakra e by and was say that the court erred okay yes so that's what I'm reading right now away from Pony. Okay, that the court erred when it held that section 161 of the Evidence Act is a condition precedent for putting weight on an admitted document. Work say evidence at the kind na o chem so ekoba say bi adu abi kra na the various factions will be in ample time will be in your bread no hwe say o krata ikra no kra then na say bia will be agitum say no kra they can presume say no kra without say bi kwa in certify and no baako and no say baako o chem sa afi it was no chem say tiri obusua na ye wrem kakra say the be ya enya emotions nya time nya bufu but the lawyer for ne ka and yes we hwe mra bi ya hwe the mra ka I mean Evidence Act in ya tia asema bi bia iboko afi it was say the court erred when it held that I check a credit card. Okay, the court erred when it held that the evidence adduced by the defendant was more credible than that of the evidence of the plaintiff. No, someone come will be at say, on the break court, ebu assembly we no, and send me back to ya. And some be to you and say, and that time when I court near more assembly. Any papa, or an lawyer, or ye witness, obi okujina adakemu. Edi adanse de master Odobroni. Obisiam nim so mbekaya. Oye interview court bo asem no be interview. On Sampa FM. On ye ya bra pani Philip Osebunsu. Aya host ekosi se adwumadie e wa Sampa FM so. On obi ye interview no ka se. Ebra onu kojina adakemu wie no. On e kojina adakemu o ka se that Lumba e wa arrest Odobroni on the 10th of April 2010. E wa that Lumba fee. Then po jina adakemu I mean, no children said that Lumba were not on that Lumba say already. That Lumba can't say they will need on any Akosua Serwaa because it was a funny cancer. Ah, now said that Lumba, it is a whole bonny one. Okay, we had Akosua Serwaa, such a diba, then Akosua Serwaa, we bring me for any young girl near there to say, what didn't want that and two I don't know about what I see. And I hope, that Lumba can't say, what the Mamma Akosua Serwaa a giant. Some upon the jar that cable castle, or not so crown that Lumba can't say, a private person, 2010, or a private person, it will be a picture be into our Nasco be a picture of them. Only the dance here, Musan. Upon a interview on Obi Philip Osebunsu, your brother penny lawyer, and so training can say was Sampa FM because he said you were so. And I can't say, on the crown account will be at some of us who not some now, and say, I dance will be the so because or say that Lumba will be a picture and a picture we can't have the name for the offense there be or one forecast only in the Omoka because on no occasion that can be a dance here. Court. Every court, a dear dance here, and our court stands some no. Ono or can will be at to say. A year to one for the Shiano, or court ran a more some query no. But who dance your court catch it to one for the catchers, I don't work on him and make her. To one for the catcher and say, on the idea dance here, quadring pa. Now dance here, Akosua, and I saw more big than Adaka, Mammy Akosua Bipoma, Mammy Judge no Sabons, and Uncle Fusu, on ya, Abijaka dancing now. Or no, yo, Mr. James Watson, yo, or yes, sister, Odobroni in your penny, any about penny, Ekuno. You will be a dancer the master Odobroni. The one for catchers on a dancing and air crowding, very credible. Now, who will be a more Adaka dancing now? Or not as a dancer. Obedient to me, a dancer come as one news on Bekaya, and more curiosity, one for my chocolate. Sansa, with dear dancer air crowding. I mean, Mamma Akosua one million to me, uncle this are dancing to be. Oh, the non lawyer for Jinamudima a year, Mamma Akosua Serwaa. Almost come will be at it. Almost come will be at it. Oh, one cat on the other court and say. Court no yam from so. Say court no ka say a dance ya papa James Watson. Ya okojina witness okojina the master Odobroni ekodi ye no. Em na the credible and say the most credible witness ah. Almost say almost ka say court no. Why yam from so. E dey omojitu wanyi. And was the court erred when it held that the evidence adduced by the defendant was more credible than that of the evidence of the plaintiff. Say ekoba say dance ya defendant study by the court no. Ojitu wiye ka sa no ya crossing chain adanse ayi maame Akosua Serwaa ono so no lawyer for any one academic and adanse that can be the adanse man. And after what was say additional grounds will be filed upon receipt of the records of appeal. Didn't say if you want to mark no court one kwan say on betimi amend and some of the other courts oba to one I want to be aka bi oba the biaba be count. Wow, interesting times ahead. Now ento was say relief sought from the court of appeal. Did you know mo hwe a few courts of appeal tie the only mother room Mr. Mikasa. The only few court of appeal want to say that the whole judgment of the High Court be set aside and judgment be entered in favor of the plaintiff. The only say the only few court will say court and more atemoni na to atemona mdi kan no atemona court to boy on the 28th of November 2025 in the year of our Lord Jesus Christ. Almost court to more atemoni na to na on certain judgment na side na fe or enter judgment for judgment of enter any in favor of Mamma Akosua Serwaa. And what the lawyers are trying to say, they say judgment na free Kumasi High Court or by Sabreno 28th of November 2025 now. Omoni in antumu say Mamma Akosua Serwaa customary wife there be omontumu afi say sister Odobroni customary wife omontumu na fe I mean the course be say court kwabu so transition from so won see omokwan na mbetimi attack so akutua na mo bia na mama kwai na kofi so abeda no ba mu akoye ye no court body na antum na free on enter judgment for omu asem no and from plaintiff no wan ya ene ye maame Akosua Serwaa fusu So on say the city and no ehun sem kakra. After it was say persons directly affected by the appeal. One would be affected by the appeal. They did kind abusia penny confused. Me did not much abusia penny confused because bra na omode assembly court and court na court this no. Na confused with a titles as abusia penny. Ya na chinye bia ma. Unti say na ya na once kakra about it. The person be affected directly by the appeal no. They did kind abusia penny confused. Tina mechanics and madam want him ase. Ebu akwa kumase. After second person be affected by the appeal. Prince Laufori, aka Odobroni, Accra. And of a third person, you'll be affected by the appeal. Transitions Funeral Home, aka Enterprise Funeral Services, Hachu, Asori Junction, Atomic Road, Accra. And that is it. And so you didn't want to someone said, yeah, it's it. Now for yes, and to us, and some will be 18 pages. There was a million who would watch it. Then to me once and for no be anti 18 pages. Now, this will be seen in Caribbean. After you trust me, the next page. Yet was near the next page. This is we are over 10 and Symbiase. Over 10 Symbiase now say okay. Over here a fair idea of whatever it is. Yet was what? The next slide no. Many say muhu I was here. I think say muhu and I'm making kind free am moyo okay madaroma. In the next slide no. Ye ba. As you mama Akosua say wedding wo. After defendants and so omunadi wo. And I watch them additional grounds of appeal. In the additional grounds, some people the other count or say they kind all you have to say will be to say the judgment is against the weight of evidence adduced at trial. Into I say, I think one buy if you come say I court by any adance ya do a de ebeda court ebe na asem no ekoso court hwe nsem no a na say e ha adwen kakra na say esi pai I say ensure that entirely because say judgment no free come say I court by any one more dance ya do adance the weight of adance no court no na judgment na dance here no I say enhia because chese dance here ni ade be dan court dance here ni nchiwa do be pie mu e court branch ni course no na omo ha temu e bai no a say the judgment is against the weight of evidence adduced at trial. After it also we must say the court erred when it held that the court erred when it the court erred when it held that foreign law as a question of fact can only be proved by calling an expert witness. It was a court here from so a big court just say, oh, yeah, foreign law say, I'm also mindful from Mumra, a bag Ghana ha. Now the bit of the dance here, if you say yes, for authentication, because so Yama will be because could be mana, if you don't make argument say, Nankan Yema was a German embassy. And I said, German abandoned with senior waha from the German embassy or Ghana. I say, and then will be if from maybe dear dance here or court, then money at the minister of Kaisa and send be by. And so much as there be almost Kase, a Kobasa court near from so. A brown court, HSA, foreign law, you wait me prove foreign law, and just say, expert about the dear dance here. Or a court Nekasa, and so, or much a court near from so. I was here, I'm coach man, be able to sing now, and actually, Madaroma, near 10 once. After I told me, I'll say. The court erred when it rejected Exhibit B, B1, and C upon consideration of Section 5 and 16. Okay, Section 5 and 161, Clause 3 of the Evidence Decree 1975, thereby leading to its fatal presumption that Ghana's ordinance marriage was same to that of the German civil marriage. I mean, the court erred when it rejected Exhibit B, B1, and C upon consideration of Section 5 and 1613 of the Evidence Decree 1975, thereby leading to its fatal presumption that Ghana's ordinance marriage was the same to that of the German civil marriage. Also, argument able to Jan said, Ghana Wadian Krata, if you don't reference, oh, Ghana Wadian Krata signature, there, but German Wadian Krata, no. And this are any paper, there are a lot of only courtroom, Rabbi. Young question man, and say, be a man, I may bomb Maka. Almost go to Section 5. And after Section 161 of the Evidence Law, and that's the Evidence Decree, young conquer Section 5. Then Section 5 eka was the Evidence Law. Nafi yen tiasi na bibia and so enya boko abusia ukoshe Evidence Law Section 5 wa. And Section 1. They started with Section 161. I went for Section 161 Evidence Law. Say, and I'm can say a signature is presumed to be genuine, authorized if it purports to be okay. Section 161. Clause 3. The clause 3 then say, clause 3 then say, TNU. Or Church now say, awade kra na se krata bi be free abrochi na se kontu aba Ghana ha ne yie mu ne kwan so se obi betim so obi nsa be hyase na make se wo chem se Ghana aban na musini wo ho enye sa se Ghana aban eni na musini wo sa aman so a Commonwealth man no man a English aban na colonize here no emu bia wona musini wo no obetimi ade the uncertainty so na ba be dia dance say o akrata ekwa ye kan wase be no kwa ekojin but o hwe sa akrata no a ye de ye nyina so na anaso o chese call de ye nyina so kan na ene ye clause 1 over clause 2 or say such certification such certification must be signed and sealed by a diplomatic agent and medical can but over clause 3 one so the same evidence law now clause 3 now can be also if a reasonable opportunity if reasonable opportunity has been given to all parties to investigate the authenticity of a foreign official signature, the court may for good cause shown over that it be treated as presumptively authentic without certification. It's a bit could do baby. Court bet me ashame. Now what you so Kata na kwa dimu ewa bra yen certify. Na no be dey ekoba se bia there is a reasonable opportunity accord yama parties ni na say omo hwehwem. Enwe se nkata no aba be di court no ye no kra. Ntia bia sabra nkata om di ba court with respect to Akosua Serwaa award the nkata no. Evidence law section 161 clause 1 na indigenous so clause 1 and 2 indigenous so abujamin chim yi say evidence law section 161 clause 1 and 2 and you indigenous so na dey bia you na be kwa betina make say oh yes mran ni say akrata bi fra kontom ba bi e ba ya man Ghana ha e was Ghana ba na musin on nsa hyase o teams ne dey be dia dance e enye say Ghana ba ni na musin wo ha e was Commonwealth man no na musin o no so dey set teams ne dey be dia dance na na dimu but section 161 of the evidence law okay clause 1 and 2 now back clause 3 now clause 3 no so okay bibi or clause 3 say clause 3 na say okay na say or say tell you if reasonable opportunity has been given to all parties to investigate the authenticity of a foreign official signature, the court may for good cause shown over that it be treated as presumptively authentic without a certification. You know, the court Emma parties ni na in this case plaintiff Akosua Serwaa defendant allow for but the more we na ambre say omu yan to ombu as na omu hwehwem omu investigate kata no aba no say e authentic say papa na say papa na omu na to ombu as hwe ehwemu anye court no hwem na omu na hwem no omu say no kra ene court no yiye muti for good caution e betun agi atum say ene kata no e authentic e wa bre kra yen certify e wa bre bia Ghana ban na musin on nsan hyase emfa maye ana say bia Commonwealth man no ana musin ye was am so omo nsan hyase emfa maye enti I mean this is also a clause wa nanka lawyer for no e argue say anka except you court no betimi ahwe nanka wo hwe the third clause ya anka betimi agina so na wo de agia tum say o ene ma Akosua Serwaa wa yen kata no hwemu no na hwem na ye no kra anka betimi agia tum say ye no kra e wa bre authentication bi ama because omuna di one dance here pass you know any same way and this Ghana same way typically called bear 2 years bear 3 years bear 4 years near there we na nananom abusuapani sabre pentem ayaye nti na opese me na court pese omuna se omba yaye na omaye because no omasheda it's not court aye bibia one year within bear say 1 month I mean say 1 month odi bu asem wiye enti na say na brani swa na bia na brani ntimi ma kwanya ema I for na argue I make this argument with backed by this law you now a brain is one a brain me allow one ntimi authenticate document you free Ghana's ambassador or na say Commonwealth Ghana buy na musin or no and then come say court bet me revert to the third clause of the section 161 of the evidence law say if reasonable opportunity has been given to all parties to investigate the authenticity of a foreign official signature, the court may for good cause shown over that it be treated as presumptively authentic without a certification. It's no more argue say and yeah na ye mu a omo de na omo say court no na ko betumi ate asiasa no revert to clause 3 no of the evidence act clause 3 of the section 161 of the evidence act na ko ate asiasa na ko omo na hwehwem no magia to abai bi authentication krama because this is a case according to lawyers exam with mama Akosua Serwaa betwim say omo twe krata de call the Ghana Ghana embassy in Germany on the days as an omoti onka no almost there be ekwa bibi sa enti sa de na mo so mo ntwere emfa nko foreign affairs ministry of Ghana na mo twere ba foreign affairs ministry ba almost there be na say ekobia kwa say na bra so kwa na ekọ And it is no fault of the lawyers at that time. The lawyer could see phones or almost just say, lawyer could see phones was our and to normally say the section 161 of evidence law, and that's evidence act no clause 3 of the section 161. Yeah, a chair say, I mean, say, Koba say, you go to bit me my bread. Now, party no be a shame, only to say no cry. Yeah, you to nothing. Yeah, the call without say a best certified because of when allow. Until almost say, almost can't say, court no yes, I'm from Swan. On your men I make come away for no, and I can say, said yeah, is TNT. Afe, or can section 1, we have this, they make a mathematics, Yamadama, or can section 161 clause 3. And also can section 5 of the Evidence Act. Let's go. Section 5 of the Evidence Act. And also the Aneka. Evidence Act Section 5. And no quite one from Pony. Yes, Section 5, Section 5, Section 5. Section 5, Section 5, Section 5. Okay, yes, I was here. In the Section 5 of the Evidence Act, no, I'll say erroneous admission or exclusion of evidence. Erroneous admission or exclusion of evidence. It will say no finding, verdict, judgment or decision, where clause 1 no finding, verdict, judgment or decision shall be set aside, altered or reversed on appeal or review because of the erroneous admission of evidence, unless the erroneous admission of evidence resulted in a substantial miscarriage of justice. It will say, "Sekoba be a court to the assembly." Na court the assembly, no. Ebi ana mfumso bi ana say yes mfumso bi ebai. Ebi mfumso ebai no. Ekye ni ba ka so okoya appeal a. Ebe den say court be set the decision aside. Court be set aside the verdict. Ana say bi a court be set atim aside. Nemom court be set aside there. Eje say sa mfumso na ebai no. Enya nsonsanso ewo asenie no court no so. Ama nsonso mfumso na ebai no. Akwa mana ko wie level bi say ama ebu atenten ne animtia justice ebu atenten ne animtia na say ema aka atenten ne ahwa no nko na beboa ama court. I mean ebeka say na esa dia obehwem na wa set aside and say obe reverse and say obe review erroneous admission bi a ebae ene ebako afei or say in determining whether an erroneous admission of evidence resulted in a substantial miscarriage of justice, the court shall consider in the court ebe kwa court won say atemwe bi obu ye no mfumso bi ebae ya eye mfumso ebae adanse no na bi a enam so man mfumso by court be hwe ne bi na court be hwe whether the trial court relied on that inadmissible evidence and whether an objection to or a motion to exclude to strike out the evidence could and should have been made at an earlier stage in the action, and whether the objection or motion could and should have been so stated as to make clear its grounds, and whether the admitted evidence should have been excluded, and or the grounds stated in connection with the objection or motion, and whether the decision would have been otherwise but for that erroneous admission of evidence. Enti ochem se enema ebeboa so enema ebeboa na ama court ebia aseni bi court ebuowie na court o da bi ampa yenhwem na review of nsem o mabekan yenhwem na yentimi mu a because on normal day omche se court ensa anya review but court be review a is enema bobo so say ebia atemu na obuaye no enam that erroneous I mean according to the section 5 of the Evidence Act no or just say this be a table na wo boy no hwemu a eye adanse bi e ba court no e bia wan hwe antoto hu yenti abo am na konya nsunsanso e wo pepepe nya atentini bi na wo say gba so ko say e ma atentini bi to ba ha e ma atentini bi entwanchia bi ba wa atentini mu dia e the court beto no bo ase na wa hwem na what dia 2 years said yesterday na lawyer for just say omo de omo hwemu a court no e ye mfumso esanse ye wo sa amra we say wo no mo a emra we etimide oyene ni ohaw ni amane ba esanse court bu asem wie na ko ba say wo na wa ye mfumso no a very tough say ji say bia mfumso no e wo nyina so say the medical aka say enya nsunsanso e wo atenten ni bia na wo say ba so enya sa court no set aside the ruling court no set aside the final verdict and as a judgment by inti na lawyers for can say clause me nti omo kan will be at say the court erred, thereby leading to its fatal presumption that Ghana's ordinance marriage was same to that of the German civil marriage. What I want to say, clause me any adem from so be by yeah no tin ma te one for share so bu say Ghana awade enkrata ene Germany awade enkrata eye ba akwa na society but omo say entisa after it also be mu a after omo eto omo no rem yi particulars of error or say for a brief moment of courtroom inspection, unchallenged evidence of court proceedings showed that no reasonable opportunity was given to the defendant to investigate the authenticity of the aforementioned exhibit due to the court haste to meet trial timelines. So, almost say, almost come will be out to say, almost share more court to demo abobo ni adie. Almost say, a dance yahodo. Yeah, defendants say, why na confuse Odobroni and Afi transition funeral homes. Almost who say, yeah, sure that makwan. Ma defendant yi wo anhwem anto ombo ase Asantehene adanse anase no crowd do ya ewo exhibit a de beda court no nti exhibit wo de ba court ma me Akosua Serwaa na lawyer for exhibit wo de beda court bi che say extra free family book mu ebi adanse ne awodo no che say ena so na brand su awase ni nti lawyer for na e kan ena so na brand su awase ni nti no no question say unchallenged evidence of court proceedings show that no reasonable opportunity was given to the defendant to investigate the authenticity of the aforementioned exhibits due to the court haste to meet trial timelines. Intino, nanka, bra was the demana, alaya photo was no busy and some near dancia, Yamame, Akosua Serwaa, alaya for the bedan court. Nanka be a defendant, no, also examine or investigative at court. Almost as not brings on the court to a maquine, a moment may investigate. Yeah, in national court person will meet the deadline because nine check obey you know December 13th. The court is was 28th. Next I can be 15 days. So national court person will meet the deadline according to a lawyer for instance one day to. Now if you know that say questionably the court having deprived the defendant reasonable opportunity to investigate the authenticity of the said exhibit, fatality endorsed and overly relied on the erroneous argument by counsels for the defendant, thereby resulting in erroneous conclusions by the court. Into what you say, and so we are up to now. What busa honsem? Omo ntiase. And then omo busa honsem. Yeah, omo ntiase. Omo say, court no, deprive defendants no. Omo akwenya se be yambo to ombo ase. Na omo ahwem because emrane say koba say yentimi certified crata na be abrenti yentimi certified awren crata na free am hold also ba no a. Court no mabre. Emma plaintiff ni dey omo ye mama Akosua Serwaa lawyers omo na akopadi aba nti omo ni say authentic but defendant lawyers no omo say court ma defendant lawyers no omo to omo wase enko hwehwe nsem na hu say character na authentic and asanya authentic but na say brain strength no court ama omo kwan sa ama omo akọ hwehwem nti no so ko basa na ase abu niema bia nimtia se na omo ka na omo kata em abu niema bia nimtia ya je say abu pepepe na tenten na nimtia fatality of justice say omo ka na e wa say and there's a fatality endorsed. A bass answer na ama lawyer for and someone or more can argument lawyer for you only say erroneous argument by counsels for the defendant. So no one say lawyer for example one more yet one business court yes it's Odobroni na confusing or argument on making no make you a court no yeah court just do boas it was erroneous. You know some make your argument erroneous no court now so Emma court and so it now results by no now erroneous conclusions by the court it no court now erroneous argument and I say erroneous arguments yes erroneous arguments by lawyers example the defendant na confuse and say Odobroni e fa re hon sensem court and we now so bu asem no a court coming to an erroneous conclusion na say conclusion court by no omo say from so ewom say this here after omo to so be no say that if reasonable opportunity had been given to the parties to investigate the authenticity of the said exhibit, the trial court would have ordered the said exhibit to be treated presumptively authentic and would not have come to the erroneous conclusions and findings it arrived at. And the dynamic from the Evidence Act, Section 161 clause 3. I say, and some of the ebia, baby, I press your authenticated documents, no, ya train ma. Yenya nyina so bia adanse bia ma bibia nhede mfiri mu ma emra no a court e kan ne say ye betimi ama lawyer for no bre lawyer for no and all parties plaintiff lawyers and defendant lawyers betimi ama omu nyina bre we ye de emra no mu ye betimi ama omu nyina bre na court ore say ye de krata no aba na mama na mu hwehwem and na mo hwe se krata no aba no no kra na ansanya no kre authentic na ansanya no kre and na lawyers a ejina mo di maame Akosua Serwaa make argument say court enya bre and na ote ase and na ojitum say okay sadia amonto mo ase na mo lawyers a mo jira mo di ma plaintiff mo lawyers so mo jira mo di ma defendant this is Odobroni lawyers and na to park na ko fusu other Roma na lawyers mo nko na argue and answer krata lawyer for di abani monko hwehwem say the Evidence Act section 161 clause 3 kan monko hwehwem say no kra na won fa ho anu yemra court na court mo bre no hwehwem a lawyer for nche say nka denia ka lawyer exam di my sister Odobroni o ma ko hwehwem mo say krata ya be pay mo court no kra because como say authentic the court so be gia tum say even though certification and authentication be free Germany mine and the court be gia tum say ampa Mami Akosua Serwaa wari en krata na work court na no kre in sad dia oye a legally wedded wife it na nka aboa ama court ebua no said say na efata but unfortunately anko akoman say lawyer for yeke it ni na lawyer for argument o making na say court to ne boase ama wa ma ample time ama lawyer for no enye wo mkwa per se wo mo lawyers ma Mami Akosua Serwaa yeah they are privy to whatever it is wo mo enim krata ni mu krata yin na efro makachi na aba. But lawyers are not going defendants are not making arguments. No, or they don't want to say court on the boss a palm or and a winya betray and mom fishing same money idea and come back to think can say and be a court baby boss or can come back say be a court baby boss say yeah Mami Akosua Serwaa here crack out the crown and yet I mean on him to na on him to so a legal wife but say oh nya brema na and a lawyer for na ko hwemu and come you mo gidie pass a court beba abi boss am say Mami Akosua Serwaa legal wife because anka dancing na be show ko wo mo hwemu anko mo se krata na janim na nya from so nti no so yensem bi a omodi tudwa ye de nso etwon se dia esi etie afei omoto also say omoto also bi him say the learned judge misdirected herself in law by treating plaintiff's inability to authenticate a German marriage certificate as a choice within her control. Do I say yen kam obi anta lawyer for no homa kansem po abusiam ye show see yesua de enye say bia bia ogyina wonsem obi aye yesua de from po and we are learning a lot me kwansem nim say for be evidence law I mean who say bebre the lawyer for na say omo kan say omo kan obi ate na the omo kan obi ate ne say ekoba say Mami Akosua Serwaa bibi nti wantimi authenticating ne krata na wade krata eno nye ono mfunso because it is not within her means say obe authenticating na wade krata say the medical aka evidence law section 161 say there be just a Ghana ban na musini oho but omo che so mo tre ko ma Ghana ban na musini oho na we ka say na omo tre ko the days ansa na omo tie omo nka afei the same case omo tre be the ba Ghana ha the bread mobile mind Ghana ha say nso a omo a ejina mo de ma omo twe bi the foreign affairs ministry director omo twe foreign affairs ministry omo twe ye omo nti omo ka echi omo beti omo ka obi a che so enye omo na ye bibisa enti no enye Mami Akosua Serwaa na I mean eye within her means say obe authenticate na wade nkata we within her means ankobe enti omo say ya Mami temuafo manyim ni the learned judge ya Mami temuafo ya wo sua de adurotri learned judge omo kan no say enfunso kakra ba kakra yeah, or misdirecting in law. Because I want to be careful with my choice of words because I am memoirsome. You're saying I'm meeting one for your chance or misdirecting with a choice or misdirecting of Bremu. Ewa bra or fan say, Mami Akosua Serwaa and me authenticating our young catano. I am Mami Akosua Serwaa pay. She said, you be Mami Akosua Serwaa no what to me say or be authenticating our dear crata. And I say, or be yes, or be authenticating our young crata or the abacot. Ena bibi ntie bia wanye anase bia na Mami Akosua Serwaa wo satu ni se e wo so he ena wo ye se da bi media da bi enti no enye Mami Akosua Serwaa mfom so enti se ogina so according to the essence we da kodan court no ogina so se Mami Akosua Serwaa wa de kata na wa authenticate nti onyi ntum se o legal wife na e hadwe because it is not her fault it is no fault of hers and it is not within her means to do that and also be a lawyers for na eka enti afi yesa to aso these are some of the particulars of error. In the particulars of error no be no bobo so asina after particulars of error no we must about particulars of misdirection therefore we rem against omo ka setemu ya Mami temu afọ ebi ani semni bi ho a anse ni bi ho a o misdirecting ho the enti de no so omo ka abusua and then my adwuma to so but be ndɛ ya adwuma ya fa to on say be ni wadoma now particulars of misdirection the can say the court directing plaintiff's counsel to have the said German marriage certificate to be authenticated without giving reasonable time for Ghana's embassy in Ghana to execute the said certification of genuineness of the signatures on the said certificate. Do I say? Or come will be to say particulars of misdirection if you are my boss. But when say court, catch plaintiff no lawyer, my lawyer say, or mon say, now what the enkrata you be authenticate. I will be one shada ma bra bia emuwa because assembly court no assembly na kwa na 1 month and you say within that time I'm authenticate here omo che say court ama lawyers ye jam di my ma Akosua Serwaa e bre ye pass o e bia ya ma mo bre be say one say I mean administrative processes there ye man Ghana say I do be bia akwa e bia o kakra ne ade enti na nka was court no ma lawyers for jam di my ma Akosua Serwaa in this case lawyer kusini na powerful na so omo bre everyone to mboasia nanka one more authenticating cratan but court no the court directing plaintiffs counsel to have the said German marriage certificate to be authenticated within giving reasonable time for Ghana's without giving reasonable time for Ghana's embassy in Germany to execute the said certification of genuineness of the signatures on the said certificate. Intinom ebra na ye dia mom so mon ko authenticate mo wale cratan no every German embassy is on Ghana by na musini wo emra no not time is any reasonable. The time it was unreasonable. The courts did that without giving reasonable time. And the woman say basa na ha dwen pa ya any kwan say basa. After it also we must say hence by so doing the court expected counsels for plaintiff to compel the Ghanaian embassy in Germany to expedite its own administrative bureaucratic procedures in the authentication processes obtained under section 161 of the evidence decree 1975 and RCD 325. And the lawyer for the church, I was telling you, wait, I mean, you're marrying me, but I'm going to say, or say, there be, my bre, say, first of all, must say, you authenticate secret, now you authenticate the one you to say, my Akosua Serwaa illegal wife. But I don't know my Akosua Serwaa. And you only want to miss authenticate secret, and you only want to miss what's for you. And I want you to know your back, I don't know. I think, must say, ne krate onko authenticate na onfamra but the tie ne say ebra mo se onfo authenticating krate ma no na time ni so pa and time ni so sana be din say German embassy ya omo na be authenticating krate no metimi authenticating krate na we because omo twe krate ekoi no omo nti omo nka and omo nti omo nka omo ntimi nya hwe mfa ho and afei omo sai chire mo abon to fa na omo say yet the same way in our to China. As I'm back home, can say that's almost what I say. Hence, by so doing, the court expected counsels for plaintiff to compel the Ghanaian embassy in Germany to expedite its own administrative bureaucratic procedures in the authentication process obtained under section 161 of the evidence degree 1975. You say, the court make us idea, and the court to say, I lawyer for you, my Akosua Serwaa. One say one for shebin koto German Ghana embassy or Germany so say chinchina one bra omo administrative processes administrative process omo de ya bibia ye kakran bibia ye wano I say one ko che German embassy de omo nye e wa bra entisa e wa bra nye German embassy I mean I wa bra nya lawyer for wa ko che German embassy say munye because okọ adwumakuo bi ho a any institution bia corporate aban mu omremo on say your bureaucracy the bureaucracy say be ye ya de bibia ye this one this one nti untimi nkọ adwuma bi mu and I say I mean government agency mu na prekope obi ye na adwuma die say wo so bibi enkoye da bi we will go by bureaucratic processes and since we go by bureaucratic processes obi ato na bo ase de bibi ko bia krata we e wo se ba ha e wo se wura ha e wo se we di koma we na we di afa na we di akoma we ansa na kwa komedu enti wo mo lawyers wo je dey ma Akosua Serwaa omo ni sa to means on be da so le prekope no makose Ghana embassy or Germany tinchina ye de krata ne back court be na wo twa na wo twa me ntamti tinchina ya hyemo mo authenticate my there be omo yes ana se court person say na omo compel omo ko share the Ghana embassy or Germany but then also omo nya ni sa said there is omo ntimi nya ni sa and nti na omo kan sa said the ICT and also your back obviously me did say muda or madaroma said the ICT no yes ntiafe omo to so biem no and brother bi na ekwu to get higher say one and omo say that a fair-minded court tell you wow that a fair-minded court upon issuing such directive under section 161 the number kind by 3 times no na ma church na Bible section 161 clause 3 no ho no ma o che say e ko basa munya bre na ye ma we afu obi ankohwem bi obi ahwe no munya hu say ageni wa yitimi gitum e wa ba ye authenticate but o che say e bra court ka sa asem nya no section 161 now o jan so say ye also authenticate no clause 3 dey wa mo so because clause 3 say ye hwa na mka na ye hwa na say bia certification ni ma alo for ya mo bre mo kwa na mo nkohwem na mo investigate mo say no crack e gitum say ene authenticated genuine e wa ban hu nya se be authenticate but anyway ebi so to one book court no nye because na sa be bi obeka na brain so it is a lawyer for no make that claim say na brain so e brain so na je o mu say na tin one for na say court no e pese opekwa bia so na wodi sa brain na wa hye say opese odi asem opese odi wi tin ma we na buy nya me na make a lawyer for na everyone say wow interesting times ahead yen to aso abusia after to aso say that a fair-minded court there's a court where you're fair, I mean, but a fair-minded court, upon issuing such directive under section 161 of the Evidence Decree 1975 NRCD 323, would have ordinarily waited for the said authenticated signature to the marriage certificate to be ready amidst the court's attention drawn to the hardship in the authentication process by counsels for plaintiff. And to almost say, the attorney now said, court to be a yafnyama na make am Mr. Madaroma me pe contempt asem bia me ni kapre am tia Madaroma na me nyama se me ne obi ebenya asem wo mrem Madaroma enti wo mo se court no alona for say court to be a pepe ya court to be a fair na e pese e de pepe ye edi ni juma fair minded court wa ankebra court the directive e ba ye directive say mon kwa na mon authenticate ma wade enkrata no mra no yemra section 161 of the Evidence Act and as the Evidence Decree clause 1 and 2 ne kan one sem but 3 ne kan other thing no which is in line everybody can check no se court to be a ejina sa mra no so ne kan asem no a na nka obehwe se ebe o ka asem mon kwa na mon authenticate a wade enkrata no ma no court to be a fair as na lawyer for ikan court to be a fair ko be twen se me mama bre metwe akopim se mbo authenticating krata na di aba and the court no beto no was o ma twen me twen because mon ko authenticating because hu hia e crucial atemu obi ebebu obi ano ebenya nsunsu so wase no so enti na mon ko authenticating ma the court kai no betwen se na otwe se musumi o asem kan o musumi no betwe akopim se ombe authenticating di aba esan se we have for chance say no ma dikan aka kire court say court krata na was authenticate no ye fa how mo ye try the call hai we mo di be for this ye tell kam we mo the response but you won't blame lawyer kusi abusunya I think say after going through all this say o Lumba still lawyer kusi I think say he deserves an apology from you asana meto aso after going through all this say o Lumba still na say bia o ka say lawyer kusi am go to be the man no a no kwenya me we all deserve lawyer kusi I was say media man be but say o Lumba still lawyer kusi you have to apologize to him because on say na because you am forcing on one check kata obi say on ya ma be say kata na ba program sometime back kata o try the command the German embassy say almost stress on here authentication here there o dey mess marry na say aba so I mean with the Yakusi deserves apology the way am for Lumba say na anu dey no do so what I say almost there be go to be a fast na o kan yam na meka na nka sa bro na court wa kan sa asem no go so to ne boase na ọmọ mo bre say okay mama mo bre sa abram de mo nkwai na monko na afei monko authenticate man say boso me kra because na for church say ọmọ so mo be ka check court court how are you from ni o krata ya was ye kwaji be yenya ya twera de akwa you say we say nti yenya ti court e be ya nka ye beef kakra fa o mai just ọmọ say e bia with that instant court na anye fa fa ma o nti no so de kakra e na ọmọ e to aso yes I want to say by so doing by so doing, a fair-minded court would have invoked its inherent jurisdiction to clarify the authenticity of the marriage certificate by calling its own expert witness to assist her before racing to give judgment whilst the very document it demanded was not ready. It was it. And now everyone who marriage certification you may court to be a your fair be nanka wɔn a ɛbɛ kenya nneɛma mu wɔn a ɛbɛ hwɛ sɛ wɔn atumi mu because the court bia expert asɛm bia no wɔn expert wɔn result ti wɔn sɛdeɛ wɔn ka ɔkrataa mi and I think that's how it is and the court bia yɛ fɛ a wɔn abɛ result to sɛ wɔn abɛ fɛ wɔn experts. Omo abe from one expert witness na nka waba abe assist omo abo abe hwem so okay but boy me say krata yi awade krata yi na say simple extract here free family book mama e genuine na say e genuine the omo say na nka court no betimi abo akole omo expert ama omo determine how genuine it is how authentic it is e wa bre kra no a na I mean atemu no e na say authentication bi ama and say lawyer for check two other options are na nka bi court betimi abo afaso e the authenticate krata yi without say bia authentication be free the German embassy I mean the Ghana embassy or Germany aba but when say anka court ma brand na for na ko hwem which is grounded in law section 161 of the Evidence Act go hwem clause 3 anyway go hwem na so jitu mu na ko ma beka say no court ama kwan ama ma anye wa ma bre ama ma anye and after say so wa ma anye no kra no a na nka wa betin stand the wa lead you wa to me say the court na to me say the stand wa witness or expert witness na nka ba abedi adan se krata wo hwem no because we have experts in all angles wo hwem no court ampa no kwese ya genuine ya wale krata ya authentic na nka ni na aboa na bibia ya asomdie but anko ankopa nsa no so yensem no bia wo mo eka e de akire court say city yes enti nka on betimi ama court betimi ama one expert witness about bedi adan se ama na expert witness bedi adan se wi a ansa na court obu asem no because na omi na nim say sa asem krata ya de hia na wo behia na benya nsunsuanso watemo so but I'm saying because court wanye nsa ya otu anamon ekokoye and as otu anamon dia temu ba ye e wa bra 1 2 sa anamon a na was otu nyina nti no so yense no bia omo eka e wa bra onim say na court we demand this akata ya enye ready after omo story be won say that the learned judge unduly hastened to give judgment by refusing to accommodate or even meaningfully inquire into the process direction for clarification she had set in motion under section 161 of the evidence decree. So I say, Omo will be able to say, Temo for your time, Germany, the number say, Temo for the before time, learned judge, your time, Germany. I'm saying, operating, I work a boat time. Our bra, why don't you say, be uncle to the boss? Now, I'm saying, some process of film, and some of them one sana, or what to me now, dear. And I want to be authenticated. Don't say, and can be also to one front to the boss. Now, obviously, we say, inquire, obviously, we say, wow, now inquire about process. Ben, I'm from, oh, and the process, I'm from one Saga cat, I'm not to be my lord. Yeah, the cat, I say, yeah, far, I say, Nadia, but I'm saying, there be, the woman say, the one for a hasty or praying at home, Yamana make a mother, a lawyer for Neka, Madama. The money no up praying at home, and now, or two son, I'm one ton of bossy. What I say, one to the wasi. Na when why quite say na process ben among how ben among near there. According to lawyers for inquiry on the aba. According to she has set in motion under section 161 of the evidence decree. Then Abuja, yeah, take your better section 161 was him. After it also be more say. Or say the misdirection infected the entire proceeding, rendering the entire judgment as having sacrificed procedural fairness for hasty record time judgment and violating others made vain. Do I say? The only say, and pre-warning a course are affected, and I say, yes, so I want to one now. Some night shall see the acquired the no. And yes, and so on. So I was so. And Tiama, I call her Timon in yeah, acquired Timon in Nama, Pepe and to was here. Procedural fairness. So the two was to an amount of remu and the two was to an amount pepe mono. Or say, court no edin sin change. So the bear obedia seven tem na was court now your record with dear seven temper. Because I'm crime can say I see the court within in terms of the seven fatter. Because now 10 she will be there. And only said it was a court the seven tem there, but court at the pepe be and also the tunes and any not on the was here. Or thinking out and change. Ena opere ne ho edi asem no se de be beka se de be ya aman agbaba ko ba se record time no de edi asem no meanwhile na nka ne bi wo ha court betimi de egu akwam na nso won fa egu akwam sa anto ne bo ase anto sa na money na ya lawyer for no ena eka afi omo say the court erred when it held that a law firm's clerk was not fit to answer an interrogatory because he was not the lawful attorney of the plaintiff. There was almost come will be to say, court no cry from so. Say, Kobasa Bia, yeah, law firm, clerk, I know what law firm be. Oni akwanya say, obetumi ayi ensem bia no, esan say, omuchem say, enye ono, and a lawful attorney of the plaintiff. Internet say, I want to say law firm no, that time Dominion Chambers, where I could see law firm no. To omuchem say, minim bi CNT bia omo kasa sem, but they be BBC, or courtroom, to be kasa sem no. Or chem say, on the Dominion Chambers, lawyer could see law firm. And Dominion Chambers law firm no, omo fa lawyer could see no lawyers, how do I carry the my mama Akosua Serwaa. Then chem one day ban say, court no here from so bro chem say, law firm, which is Dominion Chambers in this case, or my clerk, one of their clerks are law firm, or only to me say, or to me a yin symbiano, a son say, Sabra, and you on the air, and when in near, which never the Maya Mamma Akosua Serwaa, so lawyer courts no AM from so. Okay, it's not say a back home. And therefore say, the court erred when it held that counsel for the plaintiff had admitted in open court that the original certificate, as was presented, was an extract from a family book or diary, and therefore not proof of a civil marriage between the plaintiff and the late that number. On said, after change, some come to and say, oh, the able to a court a family book, any idea. And a cat him said, or can will be art to say, court near from so, a bra court near a can say, when you jump to my mamma Akosua Serwaa, I just openly our court then will say, save you original certificate. Yeah, or the bar, everywhere, yeah, ma'am, or the bar court, no, and as a character of the bar court, now extract a free Germany family book, and as a diary, yeah, no, any proof of civil marriage, or so there be a bassa, not influence one, abba, yeah, court, I did 2 more, I wanted to put, I'm thinking, I don't know, but this, only, I made a number, but to me for a number, to test me, send me higher, I'm the best friend, why? Because I don't know how to get it, I don't know how to give it to you, so. Until the my number is on the video until the we are not testing on the best because I tell them the 2 and equal move and I wish it will be a benya ubia really be a yebetin sem wasi and to kwan be so beti nya tin sem wasi and evidence acting at in our better device I'll put my number there so you already on my number on the we are testing on the best and why and that's oh hear my videos now see my number no was here o test me on the best and whatever that one say be 18-page document and yansam picture now after you trust I'll say yes, I'm not making one say or say court here from so. After particulars of error, to you know where we are. On that way. Number no. Okay, we're in front of the ball. Oh, check my videos now in your life now. Obi who was here. Why? Check my videos now in your life now. Obi who was here. Why? What are check my videos now. Like the number. Okay, I don't have it offered, maybe. But maybe the my by Grace TV number now. Number 0257 754 168 0257 754 168. But check videos in your life. They are posting now who was here. Why? Now you to us way. Now for you for the Akabi and so mama sign. And you say particulars of error. You can say the court made a fatal and wrongful deduction from the explanation plaintiff's counsels rendered between the original marriage certificate and the said family book, which were presented to the court for comparison, thereby leading to a defect and an error in the judgment. It was a court here from so, and from so a court here and said, every court here in some every lawyer will jump the ma plenty of Mamma Akosua Serwaa, every time that came no church in Simono. Then some more Becca and dance or the bedroom court. The court will things and be as was a court made a fatal and wrongful deduction as a court. Exhibition and answering to one court effort fit one for Jim Mamma Akosua Serwaa, F1 same woman who is from so a crab by. And for okay, young for so a cassia pa and a buy a far a year. Mamma Akosua Serwaa marriage certificate and have a family book and no so the beginning buy a bit dance here or court. You're the best church and sim say a court better say. Was a court no young from so and near back up. After say by misconstruing plaintiff's counsel's explanation that in Germany the original marriage certificate which was presented to the court is extracted or generated from the family book, which is the source document. The court by itself misguided understanding without seeking clarity collapsed the case of the plaintiff, thereby occasioning an injustice. It was it. Also, I've told you say family book and at the end and lawyer HM say, and I'm saying court auntie or no lawyer will tell the Mamma Akosua Serwaa. And then someone say or can ye. And as a court, I'm telling you what about court ye. Say Germany abuchmemu original marriage certificate. You the free book on the people can say extra the free book now fe and I'm say Quentino court no original so more no afa so tin say no say efa and or the ebu asem no so there be about sana court am from so after just we say the court erred when it held that SBG series rather supported the case that the late Lumba married the plaintiff customarily and not otherwise, which according to the court was more consistent with the admitted evidence on record. It was saying also court here from so say court can say that Lumba original dance here SBG yeah the court so can say that Lumba worry maame Akosua Serwaa we fie na nye court or dey so there be no so court no from so yeah no so can check court this from so we buy yes and the so dey can have a particulars of error no be there particulars of error no be say it can the trial judge consciously and erroneously distorted you I say about there say the trial judge consciously and erroneously distorted factual statement by inserting words into the statement of the late Lumba, thereby basing her conclusions on a non-existing fact by the deceased marriage plaintiff customarily. Or say, on the one said, one for say a buapayo consciously, say anya buapayo or fumuye. Yes, the one for no buapayo mu fumuye. Esan say, the one for sheda said the one kind of catenu. Emma, that Lumba, the late Lumba, Ninsen do our car. The one for sheda chia and say distorted and say or the big car or you be from say or donate that Lumba and some more car. You know, make court on some cat America. The one for the big car donate the late Lumba and say no be our car. Ewa brana is say basa. It was Daniel Lumba so be our car and be and we just so Eddie Bua no. A passage judgment say that Lumba kwano or worry maame Akosua Serwaa e wo fie e wa bra entisa internet was there be entisa said ya isi etie after it also be one. Okay, so it seems the appeal is rather against Judge Dorinda, not Odobroni. It's not against Judge Dorinda, it's against the ruling. So we appeal ruling of a court. So court can't, the court no judgment understand what it's now be appeal. And also I say so more appeal against Mama sister Odobroni and I say but they are appealing against the ruling of the court. However, let's not forget say if they are appealing against the ruling of the court, do you hear almost my question I'm making kind of or say persons who will be affected by the ruling or be affected by the ruling no Mama Akosua sister Odobroni afei sister Odobroni Nana Kofi to park and afei transition funeral homes. However, I'm a defendant, but they are appealing against the ruling of the court. And that's the ruling of the High Court. Kofi what else? Kofi what papa. And this is here. Afei, or say on challenge video evidence of the said SBG series neither spoke about the payment. No, I think it's my Okay, so yes, particulars of errors never need to say on challenge video evidence of the said SBG series neither spoke about the payment of any head drink, nor inferred that the late Lumba married the plaintiff customarily. The trial judge nevertheless inserted these words into the video and relied on same to reach her conclusions. And to was say, or come will be able to say, on the Odi Kaka say, or who said, the one for no per when we are said in some to that Lumba, and that Lumba say, or I be assembly or cannot misconstrue, and then some more can. And I'll say, video evidence SBG Baby PM of courts no the series no trim say that Lumba one cow baby and as an cow video baby say that Lumba wey ya media say bi okotua Mama Akosua Serwaa sinsa say o ware no ya Mama Akosua Serwaa fi da bi and this na so na o mogina so na say timafo gina so de kai na and so one can osa asem no mu baby say Akosua Serwaa kwa me ware no fi na say bia okotua sinsa. So what James check say on challenge video evidence of the said SBG series neither spoke about the payment of any hair drink nor inferred that the late Lumba married the plaintiff customarily. I say bien what mama that Lumba worry Mama Akosua Serwaa if you are there. After say the trial judge nevertheless inserted these words into the video and relied on same to reach her conclusion. You know, when said Timon for no, I should that in some big council the bear, or between me, I could reach conclusion, person Richie, said, be between me making arguments. I have one I can say, assemble body be. After you told me was saying that they are above mentioned non-existing and erroneous facts form the basis of the trial judge's conclusion that the disease merits the plaintiff customarily only. And it was it. Omo can say, Omo the woman says, dance here, and I said, that Lumba video be a minimum one day. I wasn't in the courtroom at that on the said day. And I say, that Lumba video be, yeah, the 144 as you answer the cast. Omo the woman say, the 144 no share down, you make count consciously. Let's say, when you find it down, or share that, and our two son, mono, or share that, and I feel, or present all these facts. Said, yeah, a bebois. Na what to me at the exam so bonus say almost says answer more a year to one for exam so and as answer what one for you carry and one would now so at the ebua so really the basis of the trial judge's conclusion yeah obua say mammy Akosua Serwaa that no worry no fee I would want you say entisa that the above mentioned non-existent and erroneous facts form the basis of the trial judge's conclusion that the deceased married the plaintiff customarily only. Let's say, or just say that Lumba, or Mammy Akosua Serwaa only said this here. Okay. Okay, so also is the appeal court sitting every day. Okay, so okay, as it stands now, when you have my idea on the best starting, and you have the beer of my baba, they have some why? I know maybe shall video, no, so I know there is a different, I know see a new own processor. Yami have the drawer, but me as swatting. That be I asked me, he said, yes, say, na efata, it's not say about after it was say. It also say that the reliance of the non-existing facts in the said Exhibit G series being an error assumed by the trial judge and relied upon by same constituted a miscarriage of justice. So I'm say, are there among the one vote national? I'm say any yes, because that video at one vote national Lumba. Also say, or what I Mammy Akosua Serwaa will fear one can say, ya can form a miracle, say teacher can tank and quiz that came. Almost say, the more our dear, our dear, say, what could tell between some. And as a wood, you'll be our dear, so it's all the twins uncle. It will be Kaya Brown, Akosua Serwaa, a file, said there be only a legal wife. Yes, the Odobroni so let's file, said there be. Ye jam Mammy Akosua Serwaa, yes, the Odobroni the year. And so we could do court near the annual, and some cost no. Court to Busaya said there be none twins are yet twins are. Yentimi prove say agye Mammy Akosua Serwaa ntisa na saa de na yenyaye Mammy Akosua Serwaa e na omuso chem say ntisa saa asem court kan na wo gina so de a saa dance na be pie mo court a omo de say court e sheda de te mo sabi onyam na make am madam ati wafo no e sheda consciously say I mean obeda na nsem no bi e de bia kan say be ya obe gina so no de aka na asem no saa asem no saa video ne ade nsem a omo kan no be bia ne wa Lumba kan say o wa Akosua Serwaa wo fie. But the moon said, for the church, you can ask them at the making judgment. And I'll say that the reliance of non-existing facts in the Exhibit G series, being an error assumed by the trial judge and relied upon by same, constituted a miscarriage of justice. Indeed, I don't see another one more. Okay, so if you want to dance, my bonus is here. Or my show, yeah, I don't see almost a call to dinner. So, and I said, one for just the boss. And I don't see first of all, and you know, almost in your credit. Omuche say na eyamfum so it was an error but we just dey bu asem ama sabia am no ka say we dey just bu asem a enye nsusun so wa asem we court is so no say attention ye bu mu mienu a miscarriage of justice attention and ye bu mienu say asem what we gina so dey kan asem no na entisa yes no ba kofi o just ka asem hu ya kofi me bon number na wadaroma me try to comment section wadaroma why be me na nyami sha obusia bona na asem am ye na you say yes Kofi see me abia my brent my member wa so me try number no comment section sisi here why Kofi me try comment section sisi here pacho whatever ma me try ho why bra Kofi whatever ma yeah abuzi am me try man fast na yento so o se o se ne bibi kakra na kwabena wusu me nua abia makasa tintin o de aye data ho ade na bibi aye kama ma try ho dem se nyanto e betom sisi here na fedi akabia so ato kama said yes and fata a whole lot even you do better 10 pages aka 8 but baby wa en bibia shede won tie be bo atra bebre na ya to aso na ya ko na ajamunya be makasa tente awuzia e de safo wan fa na me se me pe but be shia papa and net die kwabena wusu me se me pe na me shia na so be nda adwuma ya fa to ya so ntie yesom a na yesom sa madawo me bru okay Kofi mature comment section edini ya Isaac Osei bunsu and a number no 0257 754 168 0257 754 168. Don't go for my comment section or why other man. Yami shop. I was ya papa, but I say one of us member madam ma say Sabio. Aye, o de yan to us. Right. Nti na me be to us. I won't do lawyer and say say. Oh, you too many because in a small crown, the one for just the boss. It has no grounds. There's no iota of truth. But what now so the boss, it only say a miscarriage of justice. Now say, attention, you boom you. Attention, for my Ghana, if you don't justice. And you boom you know a hard drink. Tia no so yen send be o maka. E wo honum said ya esi etie. Afei ya to aso biem na ye den sem no aka somwa. On the next part, I'm say, I am from Pony. You're doing. Okay. So, as I said, the court erred when it held that the second defendant was validly married under Akan customs. Okay, the court erred when it held that the second defendant was validly married under Akan customs in April 2010 by the late Charles Kojofusu, aka that Lumba, when there was no evidence on record to support it. Was a court can't hear from so. Let's not forget, court can't say, "Mamma, I say why you really." I feel Pima Uncle the Oknoba 1991 Ghana has said. Or some because I still don't believe you. I want to fear. Say the court can't say, "Mamma, I say why we fear." Or say still don't believe so. You worried with fear. You worried still don't believe with fear. Yeah, nah. Abosome and 9 money there torso. Abosome 9 money there torso do. Our film people do. 10th of April 2010. And your warrior sister Odobroni ewufie. Then na lawyer for say court no say court ayem fun so. Esan say court ebo say that Lumba warrior sister Odobroni said they account for my city e wa afem pim oni du bosome nan no mu ne that also do e that Lumba fear one cry Tantra Hill. Ya that boat could that come dey dance. No so no say court ayem fun so esan say sa asem a court gitu mu no adanse ye se dey ni adanse bia ho a ebetimi support Sampa. That Lumba ni Odobroni warrior 2010. I lawyer for na cancer because our day almost say yeah in picture bia that boy that Lumba can saw a private person to on picture bia ho the picture ho afi just say almost say that even though na go fusu say na ya buy you of blessed memory nyamemfa na ya buy you cleanse no man we go panta down kwa ma you can dey trade am for yakupon be shia na to we say na go fusu be ka say oh so I'm typing it wrong. Mr. Sylvie. What's that? Just say, we are super. Tomo, ye wayana, obviously, I want to my own so. And there's a form number, into no. If you boy, what? So, I mate. I was woman checking number here, Mr. Madam, me checking ye. Well, there's only coffee. Yay, Bemena. 0257, I'm a couple 0247. Come down with you. Ghana for almost you now. Sylvie. Mami delete Mr. Mon Kofi. Okay, good thing is that oya kwa di no ba na nya Isaac say won so mo say there be na kwa anya kwa na wusu a. Enti Kofi mami train here. Adesafo, yeah, sister, yami sure what. Just what dem tell so no ma sorry. Oh, say me you free or na say am you free or. Ha me you free or. Enti me be pene, Mr. be pene number na. I go he de nyame abem. Yeah, metali si nyame. John Wesley nyame abem. Kofi mami train 0257. And they say, what can I do without you? Yami sure what? Yeah, I was saying for me. But I'm about my daughter. She can sell some here. Yami sure pass on coffee. Okay. And the number is 0257. Don't give coffee. 754 168. 0257 754 168. 0257 754 168. Yes. The number I'm at share on. Don't coffee. 0257 754 168 0257 754 168. Asem kweni. O say obi yeso send music. O say me roso. Me kasa kwezi so. Ade asem everade brem. Dey born na kwabren wusu aye. Everade brem ne hu mobo. Number is 0257 754 168. 0257 754 168. 168. Nyame kwa nka o say nyama wrong number. When ye mama Esther you why I like you yami atwitwa ji o don't go fi me da say what yami sure pa na onye so akoma so ade mfama vuna asenya asem keto nyame nkwa anka me ane me ama ton me ho asem me ni Assembly in your company with Asantehene. Yen to us when I yes good to now. And she yedu baby I'll say. Sa our dear court jitum say sister Odobroni yawaran no. Lawyer for just say omo jitum ye omo ntiase because omo de omo said there isn't any substantial evidence. Adanse bia no we bro so bia e betim be di adanse say sister Odobroni yawaran no because omo che say that Lumba so a private person pepi cheche bia afa asaya no kwa no omo che say adanse bia according to lawyers no adanse bia no nti omo wonder how ti one for can say wa je sister Odobroni so aware na tum. But anyway, let's not forget na go fit be di adanse say na maame ya ba yo a okwa ni bi ya me fa ne cleanse no one of the dance afei okay so go fi pacho abanyami shop why thank you so much I appreciate you okay yami shop no onye okoma so ade ma me dance pa God bless you okay thank you so much no obaku from the Bible say na ka kabi na aka won kuro o de ko ba for dem ade che na no kuro aye mabu so bebe so go fi yami shop na so ma kuro anye mamu so bebe e wo years bi mu keje ti aso for I say, oh, Jesus, Yami Shawati Kuvi, but that's thank you so much. And also, and don't I feel or make arguments, and I could make arguments say, oh, Sawa the crime, and I buy you a hobby. I feel yon on qua, I was a funny because hobby. Yamefa and I buy you a can say, I feel me, mamma for snuff for soup, and so call be. But now was mamma for snuff for soup, the dance or that kind of chess or there be, or no, I number for stuff, so I yarepa. Sabi, and I'm coming to see so here. It's not my first enough to see ya. It's not intimate with the other dance. And see, almost argument to make it now. It's a court who's ampa. Mammy, I buy your own candy and buy your own ampa. Auntie, your sister will be doing your ampa. So what I say, coffee into your sure. Yan to us until all friends are winning to. I'm winning to cry. After almost at home, say the learned trial judge ignoring controverted evidence on record such as photoshopped or edited pictures. All showing that there could not have been any valid customary marriage between the late Lumba and second defendant. Also, picture be but about one thing. Picture is not much share. Wait, Mr. Mekon, madam. Now, your papa that Lumba, you're funny crazy. Any sister Odobroni. No much share. Up and down. This I'm say. Telephone is almost a free jumper up and down. Not Lumba up and down. Yeah, I'm a long sleeve. See so. I said, color no. I'm sure you good at color, but Osha say, aha. Oh. Meaning the teacher for the social first part na oko aban school government schools no madam for no so won tare bi o tai she ase no akoye no ho ase ye ko school the rabna na ase rabna style bi sa means mo kai sa picture na ye me refi na cause me hwede ba me refi na so ba ye be hwede ba enti lawyer for che say o ko ye mo ase court atina se ama adanse bi kwa ho a court bu o mani go so sa ene bi ni say o mo say o man ti anya Enfogina nasa dance bia medi e ko mo time bia medi dance say ampa Lumba that Lumba sister Odobroni ware dey mom dey e ba court ko bedi dance no o mo che so mo say na e photoshop say kaki bi sa ha say ba kaki Esther kaki deep bi kakra that Lumba no wa shebi top and down bi sa up and down tete head there be wa she kaki bi sa and the sister so she dey come fe ya na o mo I mean, they be told Jakra na lawyers make arguments. I saw her picture and call Photoshop because as a ring, na enche bonkum na eshenifa. And you make arguments that there be any concept basa. O make arguments that there be with a Photoshop. Na lawyer for just say, o mo kwa de o mo wan say lawyer for no ignore controverted evidence. Ayo mo wan say lawyer for no ignore controverted evidence. Be to say picture you photoshopped. O mo say photoshopped because o mo say picture no na you photoshopped. Na said the regular na sheni funny idea but said we be for life we be because we be am ring be na me share I mean just for life but meantime once the one must share on my right but no in church keke ema so is we as call him modernity we share na be o say o abrante I mean it be na for life keke no ko share it like church there be some I picture na back court or Photoshop me kwan court ignore you know ha adwen pa now, see no crown court, then you can say court ignore me back. And I from say, Sabucha no could be dance your court no. And no crown could be say. And yet, now Bibia say there wasn't any substantial evidence to support the claim say that Lumba our sister. What I say. After what also you say, uncorroborated evidence between the account of first defendant and second defendant vis-a-vis the testimony of VW1 concerning the said customary marriage was ignored, leading to an erroneous conclusion by the court that there was a valid customary marriage between Okay, let me take it again. Uncorroborated evidence between the account of first defendant and second defendant vis-a-vis the testimony of DW1 concerning the said customary marriage was ignored, leading to an erroneous conclusion by the court that there was a valid customary marriage celebrated on the said 10th of April 2010. You say, I don't see a crowd. First defendant near one. I think Nana confused. Second defendant near this is Odobroni. So on my dance here, what we dance here, mom. I dance here on with Dima on answer NCC. So I say, wait, can we now wait? Can we? Yeah, I don't say. So I dance here now, of course, Echo could say. First of all, I dance here now. First defendant, HSA. First defendant, HSA, I want sister Odobroni. Second defendant, HSA, I want sister Odobroni. But about no. Every away can we? I was so can we? I say, I'm going to say, it is uncorroborated. And she then sees so. I say, a see pie, so but ni na say court ni ignore and you back and I form say evidence court ignore na say and here court gina so edibu asem no e ma asem na court boy no e ma for so it brought and I say led to an erroneous conclusion and you back and you na so ko we say and here na no crepa say there wasn't any marriage of that sort because they argue said there be the argument no kwa na say one we be that can e be the dance no I'm say one kind was erroneous. Yeah, called that erroneous argument. So at the two say our sister April to 10th of April 2010. But I'm aware for which to say there be no ground there share so kakra. So I'm say the city and this an so tell can once and they check court because I'm say and then say I may buy you on there in a kind hand there. Yes. I want to be one say unchallenged evidence on court. Unchallenged evidence on record shows that the first defendant's evidence in chief was fundamentally hearsay in nature, and yet same was relied upon by the trial court in coming to the conclusion of an existence of a valid customary marriage. Because let's not forget, I'm not confused as someone can. Not confused what dancing because I know the hobby. But I check what because one said starting also no but your investigation. When investigation we no investigation ya crudging just say investigation chinye bia ni ho and also empire warrior sister na nse wo begina court wo dia adansi na o tell so yes say we catch me yes say na say yes bia na me to obi mo na court am say we that's not confuse evidence no so mama for na catch me so say oh mama ya buy you akra yes what say mama one question what say or why fa oh why nyame dia wa kan chite go abaduane si jaso di wo okay mama for na so okay ono so say ya wo yare bibi ntimi ma ani ade enti wo mo kada check say na dance ya wo gina da kan di ani na do yes say oh yes say sir yeah I mean and rely on facts sana wo kan e dey check court say the city enti no so omo bo ho wa e check court of course ni na yense no bi a ye kan e dey check amansan said ya esi enti no so e baako now after to also be mu a or say existent and yes and no na kufusu kwa answer obeka court omo che say now was a court I mean now it wasn't challenged so it wasn't challenged it allows Sama they having a way through said the omo kan e wo hono yeah no so court chance the clear conclusion after say evidence on record shows that the plaintiff at all material times denied second defendant being customary married to the late Lumba, and yet the court in a fatally insidious conclusion noted that the evidence that second evidence was held out as a legal wife was not challenged by the plaintiff. You say, I dance here about court you never be the dance here say. Mama Akosua Serwaa. Ojitum say is Odobroni yan ware no and I say onye ehele aduma ware no ofie onye customary wife said the city nanso wo say ni nyina mo court assign etwaso ekoko bu atan say evidence ya wo mo nche wo maka che say sister Odobroni na that Lumba et no ekwa abonta na so parody no say na yere Mama Akosua Serwaa kwa anye ho hwe Mama Akosua Serwaa I mean one challenge sana court e ka ko use was one okay it no dey challenge o chere say o mo we for them say Mama Akosua Serwaa ni nse mo hakin na o chemu jitu mo aka wa chere o ba bia say is Odobroni enye onye yere ani kunu ware no okay enye me na make on Mama Akosua Serwaa krata na pin no krata no e no ka say da bi ono aka da bia na say ne krata na dance o da ko nya o chere say is Odobroni nye hira e ye ne kunu da Lumba ware no nanso court e gu ase no say that Lumba e pro sister Odobroni se ne here e wa bra ye maame Akosua Serwaa o ye plaintiff no wan ka ho hwe eno so ye baako that's a one challenge. Afi, or say, but the trial judge by this assertion and assumption imposed an admission of material facts of the plaintiff, whereas same was not true per the evidence on record. Do I say? And the question as a court, no, I mean, kind. At the share, Mamma Akosua Serwaa, I say, and I say, what to your Mamma Akosua Serwaa also say, your Mamma Akosua Serwaa, say, edutum said that says to Odobroni, I'll be Mamma Akosua Serwaa so. Onyin to Nampo, dance or the Abadan court, be anxious or dear to Sir. See sister, said the AC, and the announcer who sent Kakra, and no. Afe, was it by relying on the said erroneous factual admission which the Leonard trial judge imposed on the plaintiff, indicating that second defendant was a legal wife of the late that Lumba, it occasioned the miscarriage of justice against the plaintiff. What was it? And I'm saying someone court to kind. So that Lumba already Mamma Akosua already sister Odobroni said Mamma Akosua Serwaa challenge to Sadia, Nina can send me one, Nina Chester where you know. Also, only say, ever say a hard dream. Pa, then I'm say a hard dream. Now, court, only say court carry to Mamma Akosua Serwaa, so by Mamma Akosua Serwaa, that's not the fact, you know. Next, any your book attenting your book attenting you know, there's a miscarriage of justice, your boom, you know, said the city. And I think, I'll just be able to say, the Leonard trial judge by these erroneous assumptions and inference consistently undermined and collapsed the case of the plaintiff, whereas painting a perfect story. Did you was it? The Leonard trial judge, by these erroneous assumptions and inferences, consistently undermined and collapsed the case of the plaintiff, whereas painting a perfect story for the defendant. And was it? And then some assumption we won't say, court which seems so yes to Odobroni that Lumba worry no, but Mamma Akosua Serwaa and Mamma Akosua Serwaa that Lumba worry no, that is to Odobroni, Mamma Akosua Serwaa is to Odobroni that Lumba worry no, Mamma Akosua Serwaa and challenge that Lumba kwa pro no baby then so one challenge ni ade no or ka ama aye a lawyer for jam the Mamma Akosua Serwaa say omo ka say sa asem no course so sa temo no course so na temo for jina ono an assumption so any ono an inference de ebu asasem no eba sa na say Mamma Akosua Serwaa asem no I mean ayi asem no firo na say akola so Mamma Akosua Serwaa asem no egu Mamma Akosua Serwaa asem no e no Odobroni asem no de a painting say a perfect a perfect picture for Odobroni a case yentima ko ban sa we are friends one kan. And I will say the court erred when it held that the evidence of DW1, the witness for second defendant, was credible. That's the boat assembly here can I say the court erred when it held that the evidence of DW1, the witness of second defendant, was credible, coherent, and consistent. Was it? Court ni yen so. And was court yen say e bra on that boat e bra court bu asem wi on obi Philip Osei so Sampa FM e interview e no ka say on kura bra o adja that can we e opie no court mu no ti wan fo hu no ti wan fo say what dia dance here what dance na come up na wa obi na dance adaka mu na no that be na me Akosua Serwaa no na ba mama judge na Osei Bunsu mama Akosua Serwaa dan fo no afei na ko fi su so be na adaka mu dia dance no woni aka na be dia dance but che say ti wan fo ka che ne say on na dance na obi di no e ye kroje on na wa jina dan adaka mu wa dia dance ye kama yeah, if you be no, yeah, dancing na papa could you can say that Lumba e wa yo Odobroni time for 2010 after omo war no on busa that Lumba say na say yes o ye na Akosua Serwaa ya na bo enwom ne ade e ho e na that Lumba e man so chief there bi wa jano on the man Akosua Serwaa wa bi any ade enti e ho na that Lumba catch so a private person enti mo bi en twa picture ho. These are some of I mean the we here be pia mountain I say coach another the board back say court say you wi asem no the one for Shiano, our court or baby. No questions. When I wait, dear dance here come up. I'm not call kind. And you're not kind. That the boat, where the public knowledge in American Sama. That the boat scratch setting one for them my chocolate. On it, Obi, as a pair from the year interview. So say, you bring us you shy, you bring us audio, no, and that's our video, no. Yes, now a phone call with Philip Osei will be as a pair from Ecosystem. And what can't say. And also, there be court no year from so can't say, a year about the boat. On na dance here credible. Na fei e coherent that's also consistent that's one na dance here credible after say so come o can be so pa na kwanso I don't know how to say and this there's a court here from so after say the trial high court erred it's really a high court or say the trial high court erred when after admitting the extract of the German marriage certificate it still put the onus of proof of the authenticity of the said German marriage certificate on the plaintiff. So I say court na here from so na for so court here say bra court to me say And okay, extract yeah abey as extract about court extractor extract of the German marriage certificate. Next still need that was also a day proof of authenticity in the toe. Mamma Akosua Serwaa lawyer said when I'm prove say authentic. Because if indeed say extractor called you say extractor a year from the marriage book, German marriage book, yeah, from the German marriage book, now court are to dia. And you know argue say and then say you say our dear be but so you know to say extract from the German marriage book. Then so in the next 10, okay say still won't prove authenticity no. Now I'm say high court no from so ye pa. Yeah, any assembly to answer so error on and that's why be an orca. Of the particulars of errors now I'll say that a reasonable mind I was just telling you. And see, I think say we are getting it. And then my turn was now person and something now you tell here because we will never be quite lawyer could see a be a bottom one for chi, a be bo be a sister Odobroni not to pack lawyers a cheat, not confuse lawyers a cheat. They be better see it. Until we are, you can carry we are what's not say, I'll be to make you a conclusion. This video will be there on YouTube forever. Or people say yes, because this issue a landmark case, what the interest with the you know. A case whatever the outcome will be, a bit having a redefining moment in our country. You bear other content, but this issue you be there trade be a tina be a cut every other about 20 years come. Now, I'll say that a reasonable mind upon conclusion that plaintiff's judgment that a reasonable mind upon conclusion that plaintiff's German marriage certificate that a reasonable mind upon conclusion that plaintiff's German marriage certificate existed than its non-existence would have shifted the burden of persuasion and the burden of disproving the existence of the said German marriage certificate on the defendant. So, I mean, I'll say that a reasonable mind, upon conclusion that plaintiff's German marriage certificate existed, than its non-existence would have shifted the burden of persuasion and the burden of disproving the existence of the said German marriage certificate on the defendant. It was say, no question say, I brought this dance here in Abedi, I dance here or a court. Jacoba said, Anka court, editum, Emma, who quite no credit, German certificate in a shame near the into as a steer. And Anka said, Obi prove as no, a lawyer for or mere lawyers, Edima defendants who go on and argue say a German Akosua Serwaa. And he said, the question said, upon conclusion, and a bit told you, and I said, court, everybody told you, I'm here to say, Mammy Akosua Serwaa and Cartan, as a steer. Then, a lot of folks never do my sister Odobroni, and I'm not confused. Or one that bet argue, and I saw a better Tom say, also prove say, our real not exist, and I said, marriage certificate no exist. And I said, German marriage, it doesn't exist. It is also a carrier on which at their chair am assigned. That is what it is. I will say, hence the failure of the court to direct the defendant to disprove the evidence of the probable existence of plaintiff's German marriage certificate or plaintiff's German marriage led to a miscarriage of justice. That's great. I'll say, hence the failure of the court to direct the defendant to disprove the evidence of the probable existence of plaintiff's German marriage led to a miscarriage of justice. And you know, and now which is in this case lawyers for defendants. Defendants say why I don't know who soonest or Odobroni on the aka. One announce on which I say, Munchem the entire Mokacha course a jai, Yamami Akosua Serwaa. To one number disprove the German marriage. So, but now said, on which I say, court armor quine undirected defendants, yes, Odobroni lawyers. Say, one won't say the entire or which two say Mamma Akosua Serwaa, away and award the encarta, and yet genuine. I say, Mamma Akosua Serwaa, now what the German marriage certificate, and yet genuine. Court to Amaka pass out to the mom's on Monday. And the Bassana say, you what Antintia, I am miscarriage of justice, so they are lawyer for your air. And on a normal day, a lawyer for your wife gives you a Radiani or the Encarta, yet no no credit. The exists no on a lawyer for your gives a state. And the normal day, no one will oppose the motion, and as one will oppose the defendant, the plaintiff, no. Also much the entire existed. But I'm say court, I'm going to say court to Amaka say plaintiff, no, and as a defendant, no. That's what don't believe in the rest. How much the entire almost Mamma Akosua Serwaa that Lumba wadi anyhow. Omujama wadi anyhow. Court to Amaka mama yen santi. Omu say basa na justice and omo bu na ntia. Atentene and omo boom yen say. So on sa no moka. And you know so yensem bi a ono waka e dey actual court nti I mean that is it. These are some of the staffs are of nina actually way Dominion Chambers and a tray like you see goes in that church in kama abra or file for appeal no earlier. I think there to also be one. I think there was some part be and also about can be now you're finding now okay this proposed amended notice of appeal. Okay. Proposed amended notice of appeal. I know the 4th junior is a currently a law. Almost so FRA be the car. And there's some few pages, 3 pages been afe. You're finding now maybe now when you I think say 1, 2, 3, 4, okay, 5 pages. But if you are watching, you want to from Mary and I think say when you have been break a career, but mama don't bring when you into us. Wow, I did take it time, Baba. Anyway, me papa ya osani iska wa me. Kofi za kofi nyame hwa wate me da se pa. Me da se. Nyame hwa no wonye wakoma so ade ma wate. Oma bibia nkoi ma. Now, enti afe yaba the proposed amended notice of appeal. Deep family we am the best send over daroma. Why? Afe yaba the proposed amended notice of appeal. O say ni na ya appeal no won sensem no a afe ni obi ode aba ode ka ho ni ade. And how the okotu mranko a she has said grounds of appeal. We are bringing to the Emma straight to the grounds of appeal. Na yankin kind of. Or much him say, or can say judgment is not fine for on person court set aside. Part of the judgment of the High Court complaint of the judgment of the High Court by 28th of November 2025. And with the only on air complaint. Say the entire judgment of the High Court dated the 28th of November 2025. At time of Kumasi High Court by now 28th November 2025. Almost appeal against. And I say, yes, almost appeal against it. And I almost complain against the entire judgment. Yes, be a from baby. After grounds of appeal, the learned trial judge erred in law when she held that the plaintiff or appellant failed to prove the existence of a valid monogamous civil marriage contracted in Germany between the plaintiff or appellant and the deceased Charles Kojofosu alias that Lumba. It was said, court near from so a bra Odina Muna can say, Yamamia Akosua Serwaa. When to me and our dear, yeah, or that Lumba one, then now you be say legal marriage. Ordinance marriage, civil marriage, yeah, a valid monogamous marriage. Our percom, yeah, oh, what it be out to me what being count. Or on the court, no, Eka say, I was just waiting to me on proving any 1 year legal wife, no more customary wife, likewise Odobroni. And a lawyer see an amended bill, you almost say, an amended grounds of appeal. I'm just saying, there be antisa, and no more can a sneak piece. Court no yam from so. When I say team 1 for, yam team 1 for second. Or yam from so cast from Akosua Serwaa went to me and prove this or that Lumba one. Or yam from so. Of a particulars of error, or chim you say. The learned trial judge conflated proof of foreign law with proof of the fact that the learned trial judge conflated proof of foreign law with proof of the fact of the ordinance marriage contracted in Germany. And to say team 1 for now, or the proof of foreign law, and then proof of the fact say, yamami ware our Germany no. And say, or I mean, or conflicting like I'm say, maintenance kakra bemu, yeah, nina a boom come so kakra, near back. Afe, or say, the letter trial judge failed to appreciate that the evidence was proof of foreign law. No, I think say no na omokase. Foreign laws is the same as Ghana laws, and here section 5 of the Evidence Act. And there are times we assume that foreign laws no are the same as Ghana laws. Until they enter us, I think say almost can be on. I will say the learned trial judge failed to appreciate that the evidence led by the plaintiff or appellant, including evidence of cohabitation, public representation of the deceased, eyewitness testimony, photographic evidence, issues of the union, documentary evidence tendered by the plaintiff, and the embassy correspondence from the German embassy in Ghana substantially corroborated the existence of the said ordinance marriage. Also, there be embassy I court why from so I say one learned judge, you know, I meet one phone him before. Why am from so said the can. Esan say, omo de mu chem say. Ete one phone appreciate adansi odom ba. Adansi odom di ba mi say. Adansi chese ma me Akosua Serwaa Lumba. Ono mo ti bom. Cohabitation we na tia omo tu na mo bom. Afa adansi chese ma me Akosua Serwaa Lumba. Public representation omo tu na mo nipa nim ni ade publicly. Ama man for hu bom. Afa adansi chese eyewitness testimony. Anwa our dear no hobby any idea what kind of na ya kwa interview na ya we the rinsi wa ma wo na na interview ha Emma some of the pictures now they be show bi ha say na de madarama ye nto aso enti o se ni nyina no omo e be di adanse afei omo a photographic evidence a omo be dan court afei issues of the union our de no mu nsem afei documentary ahodo ya na me Akosua Serwaa e de be dan court and afei abefo enra mo hwe about aggressive life no me the crater be free the German embassy by I mean the German embassy organ has a by to this assistant secretary or so Susan Lake around Sasha say ya o chese o ba ko say that Lumba ya our menu say no mo hwe there obekai enti the best to so no to obviously na dance ya e ba court but sadly and I say shockingly trial judge no overlook ni na say one appreciate all these evidence it in ba court na dey be di dance ni na no mo say trial judge no appreciate ni na enti no so ha atwen ti no mo trial judge no from so okay after almost that to be one almost say the learned trial judge misdirected herself by treating alleged deficiencies in the authentication of the foreign marriage document as conclusive proof of the non-existence of the marriage itself. Don't say, the one for the from Zokakra. Now, the one from Zoya say, oh, a brother Mukoya Dena, I was some authenticating Katana be binti, authenticating Katana. The one from the fan say, the Munti authenticating Katan, there, Ness, our dear be anymore. Now, almost say, enter, sir. The fact say, on want to me authenticating Kratan, say, our dear be any one. The first one want me authenticating Krata, yeah, no, any one from so. A year, and Francois, and on I was say, a young Francois, no, I was say, a lawyer for Ghana embassy here or Germany, or one else to Zana, no, be been table one to me, and don't want to blame the more. Or why and want to make us a lawyer for Namana Copasa, but the one for the finance, or want to me authenticated documents in the year. And so want to me authenticating marriage certificates in the year. And yeah, now you're my Akosua Serwaa, and someone said there be that shouldn't have been the case. Nick Wanson can yes, sir. Say what authenticate crater and the answer on your there be. Tell something more for no a year from so. Afe, yes, and also on that church was say, a boss answer was what say. Marriage documents no, so what authenticate and on that actually be but back in kind section 161 of the section 161 of the Evidence Act. Earlier church say. Section 161 of the Evidence Act, okay, clause 1 and clause 2. Over clause 3, one say simple cover say bia bibinti any there was another option. Other option and say a lawyer for na say any parties na mo di asemi next no. You bet you am bre. Say crata na dey abam. In this case, man I say one crata or dey aba court no. Mo nya bre na mo ko hwehwem. Na mo ko hwehwem na mo nyintu mo say no kra. Mo ko hwehwem na mo say no kra na ya gina no kra. You tum say any genuine without authentication. I know an koso sir. You said that bit mo for na say odina section 161 of the Evidence Act, no clause 1 and clause 2, no clause now ignore clause 3 now. It is wrong. Sana omokana. What are ma? Inti ento as say. Afe. Omo to as say. The learned trial judge failed to appreciate that the plaintiff or appellant bore a burden to prove her ordinance marriage on a preponderance of probability, which said burden was met by the overwhelming evidence on record. You say the learned trial judge failed to appreciate that the plaintiff or appellant bore a burden to prove her ordinance marriage on a preponderance of probability, which said burden was met by the overwhelming evidence on record. I say, no, kwena mama Akosua Serwaa. I was about to share the NT or yere. Now also about to share the NT or yere. Na about share ewo adansi awodo iye wo hono betimi agina mwadi adansi yi. Na sa adansi no. Na ni nyina begina mama Akosua Serwaa fam. E na betimi di sa adansi no. E di aba bedan court. Na ndi o che se o the adansi ye se fata e di bedan court wa. Na ni nyina ne kwanso na wo se boa na bibia ayasudie ne mom court no ana say okay ti one for no e ma ne kokoye say asudie no burden no eno asudie a eda plaintiff no so meanwhile they be na madiki achem say asudie na omo so someone also omo authenticate bi also omo na omo authenticating card every money be dem this is to provide what they said at their disposal. Now omo try some make authentication about but omo try na ma say omo chem ya asudie na omo so but however omo ma ne kokoye say o che say omo na so sa asudie na akwan bi aso I was say omo etimi eye enti no ana omo chem say I know much more my boss with their chairman. And for almost I say, the learned trial judge ignored uncontroverted evidence. The learned trial judge ignored uncontroverted evidence of the plaintiff appellant's marriage ceremony to the disease, conduct, and public representations of the disease during his lifetime and surrounding circumstances which corroborated the existence of the said marriage. It was a trial judge, no. The learned trial judge ignored uncontroverted evidence of the plaintiff. The man Akosua Serwaa and Kratani Adansi, American Adansi outdoor, yeah, or the bed in court. Yeah, Nina know who say, a Adansia, a near be anyone, a Adansi is no quanso. And I Adansia, a be a conduct, a be a public representation. Yeah, far only that Lumba home, a brand or Tiasie. Yeah, Nina, a coco, ye say, a CPHS, our dear Bissau. Nina know who say, a year, the one phone or ignore Sadansi Nina, I don't work out. After say, the learned trial judge erred in law in her interpretation and application of Section 136 and Section 161 of the Evidence Act 1975 regarding authentication of foreign documents. Section 161, the also medical can one send. Then I remember talk for Section 161. They say, can't tell me for mine be so bad Ghana has here. Say free agency, you free or mine, I can say when about. And I'm the woman demon say, I was a Ghana by name see or sub you or they Sasha send the backcourt. And they are clause 1 and clause 2. But clause 10 also can say, Say, be a maybe Sano Emma. And yet, with the Sakatana, a lawyer for and I say parties no more once and one court. In this case, that Lumba see me, Mamma Akosua one of the Odobroni see me. Nanka, Sakatana back court no. Nanka, Yama Akosua Serwaa lawyers, instead of Odobroni lawyers, and Akosua lawyers. And maybe a transition for also lawyers, but I'm saying only a different matter with respect to the funeral. Miss almost come lawyers, Nanka, yet the cast now say, oh, go in him. And to me now, Thomas going him on Baloma by a give on. Now, I'm not giving a cocoa to you, so I'm part Catania and crack. And now, on this outbreak authentication crime, and sachet. In terms of much as a trial judge, no, or a sound from Swan, a bra, or based on all interpreting and all apply evidence law, no, what clause Act 161. Yes, evidence law, no, Act 161. No, my kind clause 1, 2, 3. Or say evidence law, no, Act 136. Yeah, sure, also the other Act 136 one for evidence law. Now, I'll see me. Evidence law, Act 136 say. Where is it? Evidence law, Act 136. Act 136. Evidence law. Evidence law, Act 136 say. Evidence law, Act 136 say, where the relevancy of evidence depends upon its authenticity or identity, so that authentication or identification is required as a condition precedent to admission. That requirement is satisfied by evidence or other showing sufficient to support a finding that the matter in question is what its proponent claims. It means that it's being. I say, where the relevancy of evidence depends upon its authenticity or identity, so that authentication or identification is required as a condition precedent for admission. It is a combasse Katabi. I was here the court. Na Kata the court no yentintim enimu. Kata was here the court na I was say you authenticate answer. And what you want say? So that requirement is satisfied by evidence or other showing sufficient to support a finding that the matter in question is what each proponent claims. Internet say, Empower with Evidence Act no, and that's Act 136 no. The woman was authenticating Catania there. Or say a match choice option do say. So requirements now a be satisfied. So come say a dance here and I say you show a nyoma is sufficient. A bit me answer the same question. And in this case no, now what's the authenticating Catania and then be authenticating. But say my Akosua Serwaa is no, it me a show evidence outdoor. That's that requirement is satisfied by evidence. Yet me show evidence. After or which me show sufficient and you are sufficient. A bit me support the claim say ya worry no. And yeah, let's say to me MBT that matter. What question? What is the matter in question? The matter in question is my Akosua Serwaa was a legally wedded wife. This are clause impo and that's act impo. So to me MBT sa condition na any none of credit transfer say my Akosua Serwaa. Na nkrata na di mu sa etimi miti conditions ya na kwa ho gwa nya say be base on certification according to the Evidence Act 1975 section 136 no Also, when the relevancy of evidence depends upon its authenticity or identity, so that authentication or identification is required. In this case, identification is required. That requirement is satisfied by evidence. That requirement now here. It's been satisfied by evidence. And I say, ever showing, I don't see evidence be and I say, I don't see between be the big I don't see. It's your pepe. Yeah, and say she said this here. And therefore say, permissible means of authentication or identification include, but are not limited to those provided in section 137 to 161. And I say, authentication crown, and yes, we are 161. Yes, you can say, you far cut and run for on 2 or on tintim, no famra, about 137 as well. Authentication may be by evidence that the party against whom it is offered has at any time admitted its authenticity or identity or acted upon it as authentic. It necessary. It was a free. Jeremiah Bayana we see one neighbor. There could be other means and watch him now evidence acting. So until let's know make claim now. No much the entia or money team for any I don't know. And the evidence law no that's evidence act no section 136 says the section 161. You know what I say team for the I am from so error. After particulars of error, like I think I got 2 pages per year. Okay, so particulars of error no. Or say the learned trial judge wrongly treated section 161 of NRCD 323 as imposing this is mechanism. I want to say okay, section 161 now or mark clause we on say impo omina ko nhwe omji tuma ye titum say sanity but I want to say yeah ti one meeting one for the from so Emma section 161 no or the to almost say chinchinia muntu say na man we say and non kwa na ya say non kwa na exclusive conditioner you bet me the agent crata too, which is not the case. So what I say, and for such people say the learned trial judge failed to appreciate that section 161 of NRCD 323 merely provides a statutory basis for presumptively authenticity of foreign officials or foreign official signatures and ought not to have been treated as the single determinative factor in asserting the administratively in assessing the admissibility and probability, the admissibility and probative value of exhibit B1 sentence. And you can say, which is one say, no one which is so at the boss and say, I was a cosa, baby, and some who say, Omji 1 year. I foresay the learned trial judge erred in treating the absence of certification by the Ghana embassy in Germany as conclusively fatal to the plaintiff or appellant's case, notwithstanding the substantial corroborative evidence on record. So, see, one funny from so a bit of man require say, okay, fine. So, I come say, once you authenticate Democrat and the any, then one no, there be our almost say, I don't see how do we yeah, and say, Fata, I'm doing now come out, money, meeting money court. Then what makes us already a boss, but I have also ignoring now, no result to Sa and Unqua. I was the learned trial judge failed to appreciate that section 136 of NRCD 323 permits authentication by evidence or any sufficient showing capable of supporting a fine authenticity, which was not limited to proof of certification under section 161 of NRCD. So I say, the one for AM from so it's as all kind 136 in the account on now so say. And yes, be a chinchina proof of certification, quan say, baby, or my am was some for crat and red say, and penny for Ghana Benham snow in Sasha, and a man bear crate dim, then the Egyptian, so I am from soccer. I was the learned trial judge erred in failing to consider the totality of the collaborative evidence supporting the authenticity of exhibit B1 and C before rejecting C. It was say, Okam will be at Okam will be at and say, the one in the young from so, even the one in the young from so, into a young from so and say, I dance your bed die, caught here exhibit B1 is see now. Nino, one young to say authentic. Now, our children will be at your say. Now, on the one say, I hear respondents. One year, now a 7 or be young, which is Odobroni lawyers. Now, come over, break your multimedia issue. Say, sounds I want to buy a court and authentic and as an authentic. And it's nothing when you now share. Why you need that to because you are authenticate our young character. And we now the Kobo 7, which shouldn't be the case. I thought also be more say, I'll say. The learned trial judge erred in law when she failed to hold exhibit Yanamakan. Particulars of error. The learned trial judge failed to appreciate that the respondent, having had reasonable time to investigate the authenticity of B1 in exhibit B1 and C, she was clothed with the statutory discretion under section 161 clause 3 to admit the said exhibit is presumptively authentic. To say there be or come will be at it. No what you will be at to say. So let the trial judge. Now respire from so as a respondent. No one able to win someone. Sister Odobroni lawyers no. No more quite say. Betimi our breast, betimi ayen hwemu. Ehun say someone. E ma me Akosua Serwaa lawyers abada report. Authentic and answer on authentic. But you know, I'm just say when you know examining same now so Evidence Act 161 clause 3 so original so bo asem said there be wanyin tum na ma Akosua Serwaa awade enkrata no enye authentic and I say authenticating to wanyin tum afei being nature said the legal trial judge erred in failing to exercise the discretion conferred under section 161 clause 3 of NRCD 323 despite acknowledging the practical difficulties associated with authentication of foreign documents. And I make say so 161 I can't tell one now say Ekoba say bia authentication e bia na bibinti ntimi enka nkomiedu a omo court ni timi hwe na omo ewo court parties na ewo court no e won bre mom ko hwem say kracha so mesia na obantini aba mu ko hwem say no kra mu ko hwe na e no kra eno ano ehun ya say be authentication bia bi o se no so court no anye and I say timoni no e ma me timoni anto the boss anye said ya na e wo say omo eye okay. Okay, after I'll say the learned trial judge erroneously treated the absence of expert evidence as fatal to applicant's case. I be a coba say adansie and I say adansie and sefata which is the authentication. Yeah, I'm a musai now. I'm doing it when you need so at the boasem. Yeah, and then you can say a bassa. So there's almost money no air from so say. I was the learned trial judge erred by failing to wholly consider the plaintiff or appellant's case, despite the overwhelming evidence and record substantiating the existence of the civil marriage contracted in Germany. So I'm say, take money no air from so. We must also say, one nanka was what to was now share a dance here out do. Yeah, you want me Akosua Serwaa dey abeda court. Na fi wo he ebu ama bibia eboko. Isa so ya dance be abeda court am. Ni na e kire say enokwe awade bi eda so wo ho. Na awade bi da so wo ho. E wo Germany abotuma buti won that Lumba. Then so court anhwe ni sa wa tuna bo ase anhwe. Ya so no hu ni say timoni ne year from so. Afi wo say the learned trial judge failed to appreciate that the issue before the court was substantially one of proof of the fact of a marriage. Okay, the learned trial judge failed to appreciate that the issue before the court was substantially one of proof of the fact of a marriage contracted in Germany rather than a disputed question of foreign jurisprudence requiring specialized expert interpretation. Good. I'll say, and your come will be at say, the one you know, if I meet him one you know, do Rabbi, say, Ophelia say, or Beja to me say, someone about court where I come. Ye ka se pese hwe awa Germany awade enkrata na mum ye mehwe se ye mehwe se krata bi from ma bia wo do so ba ma fefro so enti na Germany awade ne ba behwe enti o make argument se be ko ba se Germany awade ne ba behwe no mo hwe no so da bi ma me Akosua Serwaa awade enkrata na kwa bia wo authenticate ya o mo se there were other means na nka ye ma metem woni betimi ahwe de age atum Sampa awade enwasem de ye kanti na betimi ahwe de atum Sampa o ye legal wife. But I can make what say, I think one another attention about the a year. Say, cut from my hood also air by a mind gun, which wasn't the substantive issue. Obviously, what they make what myself is what kind of record. I will say, learned trial judge erred when she held that the marriage certificate exhibit B1 and C were not admissible present. Therefore, course the from so broke. I say, I the encounter B1 and BC. Yeah, exhibit a course no on into no so say course no. I am from so said here. Afei o say the learned trial judge erred in law when she rejected as it would be yes in this Akosua Serwaa de court court aya to or say no from so. After the learned trial judge's rejection of exhibit B, B1 and C in her judgment, one same had been previously admitted into evidence after overruling the respondent's objection to the authenticity and admissibility amounted to an exercise of a review justification. Okay, review jurisdiction over its previous decision, which jurisdiction the court lacked. And they said, or just there be a dance any baby, and on the other court, a dance any baby, and now all much changing them with the other court. So, what the can Jibia to what the cash and seminum now, a brother and seminum, or the beatles and any come as the Senate fatter. And yet, not one say, or compare out of nowhere, obedience baby. Now, because say, oh, yeah, Akosua Serwaa, then what the encounter on says, yes, onion to Ebasa na a yaba behavior. I was ya break a car, but I cut one page into my maybe no, Yafana and Trussell. So there is it. I foresee. The learned judge erred by treating plaintiff's inability to authenticate her German marriage certificate as a choice within her control. I said, "Te when you know you from Sobra, I was when to authenticate in a way in Katana." I said, "Man, say." I said, according to Omokrati, I said, "My Akosua Serwaa and I was way," and I went to Miage, and also near or no, and I was authenticating in Krata. So almost my course no, I am from Swa, said the city. Okay, after I say, the court no from Swa bra. One to me and who's so that a Bramo Asudi and evidential burden and term. After I say, court no, I am from Swa, a bra exhibit or the Babada court no. Or Shenny no Casse. Sabi ono kasa die sa dance any ade na no ye authenticating no what's the proof answer therapy in I ha twen because what me te dance any dia authenticity no and shada and ha twen bia sa because there are options and magic bubbles no so when say court no sound from so no said the city after I'll say the learned trial judge erred in directing counsel for plaintiff to have the said German marriage document to be authenticated without giving reasonable time. I said, "Why court? Bre amfama Akosua Serwaa lawyer say, authenticate your Orient Cartano, German Orient Cartano, and no court no from so. Afi, was the court no fine? A bra or did the baby at tone also say, council is not the my Akosua Serwaa say, on for Swama, the German embassy, yeah, more a war. German embassy or more Ghana embassy or more Germany. Also, almost force your man for Mamma Akosua Serwaa and Carter man. But no sooner and you almost to me, you almost say, almost me a track or so more pay. But the Maya, almost to me and share the German Ghana embassy or Germany because they have their own bureaucratic process on the edge. So we can't just get up and force them. It's also almost to me, court no, and she don't come from home. Maybe beyond any aspect, said this here. After I say, or said Chairman will be at say, court no issue directive. Yeah, now what you say. I brought you directive say obia na wadi enkrata I mean authentication from brano. Omo no hu say na so court na to ne boase. Na court was twentwen so to ne boase. Na impose ono akra be frɛ ono an witness medical boss ono an expert witness. No be jada kema be dia dance ya. Ne kwan so ano. Ya ense hwe. Ansa na obu atem no. Na ni kwan say go obu aten. Abra nsɛm na wonya enfrɛ ono an witness say bi obu jada kema obu atem. Obu aten. Ti no so hu say court no from so. Say the city. Afei I'll say, court no say from so. Na court no say from so ni na say, e bra court no e pre ne ho na obudi atemu ba ye. E wa bra wa tie and say want to no bo say emisa e kwara ofa so kwa e Germany awade enkratem no so court no from so. After court no from so e bra na temwafo and say court no from so e bra ogina mu no ka say mranim ni ogina mu di maye maame Akosua Serwaa wagye atum say empo court wa Wajatu court was a original marriage certificate no extra free Germany our the character and German character German marriage book registry and as a book must there be and when this one can sir and I say on him too sir after what was say therefore a proof of a civil marriage between their plant and the lady at Lumba there was there be antisa cry and so court no from so yes afei church in Simaka one about 3 points was saying the court made a fatal and wrongful deduction from the explanation of the Uplands Council on the original marriage certificates and the set family book, which were presented to the court for comparison, thereby leading to a defect and an error in judgment. And I say, family book, no, and marriage certificate, no. Only the court say, the one for the should see a dantem. but don't just say that we could one for instance so they are team at the board and yeah no so one for instance so the board and yeah no so na any kwanze basa yeah no so na interessant no so omo kasa e dey afa ho e dey check court. And for say the court heard when it held that second respondent was validly married under customs in April 2010 by the late Asantehene Fusu when there was no credible evidence on record to support it. It was say court no from so a bit of Sampa cancer that Lumba kwa wari Odobroni 2010 April 10th of April abusumi and 9 to do our film premier no any etu eno I from so I don't see be anywhere to some. I will say the judgment is against the weight of evidence. That's our thing when buy it's here I don't see na emu draw the court and course. And after the Sheffield Court really sought from the Court of Appeal the entire judgment of the High Court be set aside and judgment entered in favor of the plaintiff or appellant. And you see our court say court in here 72 baby. Now more assembly a court in here assembly team one buy from Kumasi High Court. You can say my Akosua Serwaa you don't believe you know. Court in more 72 baby. He's 72 baby. Now if you want to say my Akosua Serwaa kwa and a legally wedded wife of the late Daddy Lumba said yeah it's here. I think what was we must say and how more persons are already affected by the appeal. Was your penny confused about Kumasi, Presley Ofori, aka Odobroni Accra, and after transition funeral homes, aka Enterprise Funeral Services, Hachu, Asori Junction, Atomic Road, Accra, dated at Marlow Chambers, Accra, and also criteria of the court and the Quebec will be that's amended grounds of appeal no. And so be I don't know. Stephen is here Pokukulendi law and in such a criteria or the betu ya 2 hours 41 minutes 20 seconds and undiluted ya to your boss and the nam and semwa at your boss I can semwa at the actual amansan said there is it na bibia ya boko debusia says ya the ababetu ya nyakupo ya demo appeal na bekoso and some na matum boss ya ma church and some we are for kan ma church ni nyina mo the actual tia de pima the ones mu ni abema na braba pa don hwele mienu ade sima dia na baako tia de break akaba tia de pima si na gina kopon ya adoma ebrepem de beto you bia so ye de abesom we bin ti yentimi kan messages na on ze braba de mu na masi samoje brebusia na mo hwe me ye won pa bebre ya ye de besom ti koswa the share by Grace TV na bibia nyi emfamai makra. Okay, you call really say Yakusi provide all the security doors, but armed robbers to use the armed robbers use the armed keys to open the door. And the question is, what should we be at this year? You can't begrudge Yakusi. Let's be honest with ourselves. You can't begrudge Yakusi. Because Uti and some will cause and as Uti, there's a lawyer required the workers be on the or any client into bear bias. But evidence law you can kind idea. Yeah, well, other causes of what maybe fine. Anyway, it's a matter of course, so me from people. But the Akosua Serwaa celebrate the other some more. And on Tia from Pima, and community community, Koswa, a show by Grace TV. Repem. I was here within the community, Koswa, her by Grace TV. I repem Yabishia, Yaman Cow, Macau. Bye bye. Bye.